Good morning. Um, we have a closing arguments are going to be going on over in Harmony, Montgomery, and they'll be on verdict watch. And so let's see. We can get started. Let me turn up the speed so we can get caught up. And hopefully we'll do that. And we can dip into Harmony, Montgomery during breaks, during lunch, if we can. Without further ado, here we go.
Thank you. We began early today because the court received yesterday witnesses' motion to quash subpoena or in the alternative to issue a protective order. That motion was filed by Patrick Jennings, Esquire of the Ment Law Group, 225 Asylum Street, 15th floor in Hartford, Connecticut. Is Attorney Jennings in the courtroom?
Yes, Your Honor.
You can approach, you would please, counsel table, or you can just approach the podium.
Sure.
Is the podium mic'd?
I believe that should pick me up from here.
Attorney Jennings, you may be heard on the motion.
Thank you, Your Honor. As you mentioned, I filed a motion with the court yesterday on behalf. Yes, Madam Clerk. Patrick Jennings from the Ment Law Group on behalf of Attorney Mike Rose. And Your Honor, thank you for setting this in and hearing this motion. The motion was filed on behalf of Attorney Mike Rose, who represented Fotis Dulos in a divorce proceeding. Defense counsel has subpoenaed Attorney Rose to testify in this matter, and it is our position that the content of his communications and interactions with Mr. Dulos are squarely fall within the protections of the attorney-client privilege. That privilege, as the court is well aware, has long been recognized in the state of Connecticut and across the country. It is of paramount importance to the legal profession, and case law is also clear that that privilege survives the death of a client. There are very limited exceptions to that privilege. One such exception is the crime fraud exception. And in those instances where the facts fit squarely within an exception to the broad privilege, a court may rule that it does not apply and compel the testimony of an attorney. In order for that to happen, the court must find that probable cause exists, that the content of the privileged communication, or the content of the communication between the attorney and the deceased client involved the planning or commission of a crime. Essentially, that the client used the services of an attorney and the attorney served as a conspirator in the committing of a crime, either knowing or unknowing, but used their professional services to aid and assist the former client in the commission of a crime. It's our position that those facts do not exist here. The representation at issue concerning a divorce proceeding fits squarely within the bounds of that privilege, and as such, Attorney Rose cannot and should not be compelled to testify. Furthermore, that divorce proceeding was sealed by the divorce court in that matter, which poses a further limitation to Attorney Rose being able to comply with a court subpoena and provide testimony in this matter. So for those reasons, we're asking that this honorable court quash this.
Attorney Schoenhorn, you may be heard.
Thank you. And I thank Attorney Jennings for this presentation. I did speak 2 days ago with Attorney Ment regarding this matter, and with his permission, I also spoke with Attorney Rose. I don't disagree with much of what Mr. Jennings just said. He is a little bit incorrect when he states that the privilege applies not just to communications, but to any interactions. That's simply not the case. I note that under the Code of Evidence 5-1, specifically, and under Connecticut case law, the only communications that are covered by the privilege are those that protect some information regarding informed legal advice, quote unquote. And that's, of course, from the seminal case of Tom Ullman versus State. I know Your Honor was familiar with the late attorney Ullman. I don't know if Your Honor was aware of the circumstances, but the court had ordered that he testify against his client concerning communications of when the case was on. I can't remember if it was a failure to appear case, but were certain information that was conveyed that was ordered disclosed because it did not fall within the meaning of the the attorney-client privilege. It specifically under that case and some of the other cases cited has to be inextricably linked to giving of legal advice. So for example, giving a client telephone numbers, et cetera, is not covered by the privilege. As well as if it doesn't go into the substance of the representation, it is not covered under cases such as State versus Davis. The code is, of course, talks about back and forth. So it's reciprocal communications between the defendant and his lawyer and vice versa. And the purpose is to encourage frank disclosure by client to lawyer without the fear of subsequent disclosure. And I agree that the fact that the individual, in this case, Mr. Dulos, is deceased, does not in any way waive the privilege any more than a psychiatric privilege is waived by the death of the patient in that case. So I'm not sure what the extent is of the concern regarding the testimony. Mr. Rose, Attorney Rose, is not testifying today. He's not scheduled to testify today. And he's going to only be testifying the events time-wise surrounding the production and the review of certain documents, particularly the Dr. Herman report by Mr. Dulos and Mr. Rose, without getting into their communications. Your Honor, recall that Attorney Meehan was called by the state, and he was allowed to testify to certain reactions, certain comments made in his presence with Mr. Rose present. So I'm just going to indicate that to the extent that that matter is going to be covered, it's no further. It's the same limitations as was presented with Attorney Meehan and his testimony. I also want to correct one statement. I'm not sure that Attorney Jennings was aware. The family court matter, the only thing that was sealed was the 2 court appearances on May 14th and May 17th, 2019, and the transcript and the discussion of what happened there, as well as the sealing of the report, Dr. Herman's report. Everything else remains, well, unless it's been destroyed by now, but remain in the public record. I was able to get a complete copy of documents from the court clerk's office of every pleading going back. Other transcripts were available, had been prepared and disseminated. So I'm aware of the court's restrictions. I had no intention of going to that. I have no intention of going to any of the substance of communications between Attorney Rose and Mr. Dulos. And of course, it would not cover communications that Mr. Rose had with my client, which I intend to elicit to a small degree. There were communications with my client directly by Attorney Rose. So I think that based on that, that should eliminate any concern raised by Mr. Jennings. And I will note, when I presented what I intended to get into with Mr. Ment, he also agreed with me that he did not see that that would fall within the purview, but to be safe, he wanted to make sure that the court understood that the privilege was still in effect. And I fully, not only do I accept that, I fully agree with that as an important concept.
Thank you. The court is not inclined to grant the motion to quash. What the court will require, though, Attorney Jennings, you may approach the podium. The motion requests that this court issue an order quashing the defendant's subpoena or otherwise limiting the scope of any compelled testimony through an appropriately tailored protective order. The court would require a protective order drafted by your office to be considered. It is not the court's role to draft its own protective order on behalf of any party. So if that can be filed today, the court will take that up probably tomorrow. The court does not know when Attorney Rose is scheduled to testify, but the court will consider taking up a protective order, which the court may grant, deny, or modify. And that should be filed by the close of business today.
Yes, Your Honor, and I will speak with defense counsel. I know my partner, Mr. Ment, already has, and try to tailor any protective order to the content that counsel seeks to elicit from Mr. Rose.
Thank you.
Thank you, sir.
We are still 10 minutes ahead of schedule, so we'll take our 10-minute break until 10 o'clock, and then we'll start the proceeding. Thank you.
All rise. This honorable Supreme Court now stands
Would counsel stipulate, please?
Yes, Your Honor.
Yes.
Thank you. Ladies and gentlemen, we continue with the state case.
Yes, Your Honor. The state would call Gloria Farber to the stand, please. if you wouldn't mind. Thank you. If you could please raise your right hand.
Mrs. Farber, if you wouldn't mind taking a look at the clerk. Thank
Raise
you.
your right hand, please. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I solemnly swear to tell the truth, the whole truth, and nothing but the truth. This is so help me God.
Thank you. If you could state your name and then spell it for the record,
Gloria Farber.
and spell it.
Pardon?
You could spell your name.
Gloria. F like Frank. ARBER.
Thank you.
Ms. Farber, you may be seated.
Good morning, Mrs. Farber. How are
Good
you?
morning. Fine, thank you.
Mrs. Farber, may I call you Gloria?
Yes, please.
Okay, thank you. Gloria, how are you related to Jennifer Farber?
She was my daughter,
How old are you, Gloria, if you don't mind my asking?
88.
Okay. And where do you live?
I live in New York City.
When was your daughter's Jennifer Farber?
Yes,
Okay, when was Jennifer born?
she was born September 27th, 1968.
How many children did Jennifer have?
5.
And what are their names?
Petros, Theodore, Christian, Constantine, and Noel.
How old was Jennifer in May of 2019?
50.
Now, in the time before May 24th, 2019, did you see your daughter often?
Yes,
Did you speak to her often?
yes,
Did you see your grandchildren often?
yes.
Now, on May 24th, of 2019, did you have plans to see Jennifer?
Yes, I did.
What were those plans?
Well, she was going to meet us at my apartment
Is that in the city?
in the city, in New York City.
And were the children coming as well?
Yes, they were.
And did the children show up at your apartment that day?
Yes, they did.
Who brought them?
Lauren Almeida.
Now, was Jennifer supposed to come to your apartment to meet you and the children there?
Yes,
Did Jennifer show up at your apartment that day?
no,
Have you seen your daughter Jennifer since she failed to meet you at your apartment in New York City on May 24th, 2019?
no,
Have you spoken to her on the phone since that
no, I
day?
have not.
Have you gotten any emails or text messages or any communication from your daughter since that
No.
day? I'm sorry, you have to speak up. Gloria.
No,
Okay, thank you. And Jennifer's 5 children, when was the oldest one born?
April 20th, 2006.
So
By
you-
4 minutes, because they're twins. So
Oh.
the oldest one is Petros. So there's 4 minutes apart
So-
between Petros and Theodore.
So the oldest by 4 minutes,
Yes,
okay. In 2006?
yes,
Between 2006 and 2019, did Jennifer ever miss one of her children's birthdays?
never.
And the children celebrate their name days, right, under the Greek culture?
Yes, they did.
Did Jennifer ever miss a name day between 2006 and 2019?
Yes,
Was she always there for them?
pardon?
Was Jennifer always there for them?
Yes, she was always there.
And as of now, 2024, do you have custody of the 5 children?
I do.
And since May 24th, 2019, have any of the children ever seen or spoken to their mother?
No.
I have nothing further. Thank you.
You're welcome.
Good morning, Mrs. Farber.
Good morning.
I just have a few questions for you, if I may. Can you hear me okay?
I do.
Was Jennifer's plan to come to New York by herself or with the children?
By herself, but she dropped the children off at the New Canaan Country Day School.
And the children did come with Lauren to New York that day to
Yes.
your apartment?
Yes,
Were they there at about 12 or 1 in the afternoon?
I'd say about 12 or 1, yes.
Did you reach out by telephone to Jennifer the day before she came to New York?
Objection.
Brown,
Outside the scope, Your Honor.
it is outside of the scope.
Well, it's a preliminary to the plans of her coming to New York.
Well, the objection is sustained, but you can continue with the line of questioning.
Did you make plans with Jennifer to have her come to New York the next day? Did she share that with you?
Yes, she did.
Did she mention she was first going to a doctor's appointment that morning?
Objection, Your Honor.
Well, the court allowed the question concerning plans, and so this is a follow-up on plans. Overruled.
Do you remember the question, ma'am?
Did she have plans to visit a doctor?
Before she came to your apartment?
Yes,
Do you remember if it was a Dr. Geronimus that she was going to see that morning?
yes.
And did you, as part of your making plans with her, did you try to call her the day before to confirm those plans in the afternoon?
Objection, Your Honor.
Well, now the line of questioning goes from what was the plan to, did you try to confirm the plans? And so the court is going to sustain the objection.
Did you speak at all to Jennifer that morning of the 24th?
No,
Did you call her on her cell phone?
no.
Objection, Your Honor.
Well, the answer to the question was, did you speak to Jennifer that morning? The answer was no. The court understands the second question to be, did you attempt to contact her that morning? You may ask the question again.
Did you attempt to contact her that morning?
No,
Did you have her phone number at the time?
of course.
Do you recall what that number is today?
Objection, Your Honor.
Sustained.
I have no further questions.
I have nothing further. Thank you.
Ms. Farber, you may step down.
Thank you.
The state rests, Your Honor.
So ladies and gentlemen, what that means is the state at this time rests its case. The state, if the defense puts on witnesses, the state has an opportunity, if it so chooses, to present rebuttal witnesses. But as of right now, the state rests its case. The court has to take up at this point legal arguments. And if the defense has witnesses ready to be called after those legal arguments, we will resume the session. So please do not discuss the case. And we probably are going to be in a much longer recess than normal. Are there defense witnesses ready for today, Attorney General?
Yes, Your Honor.
Are they ready this morning?
We were informed that they would arrive by 11. We didn't know how long the state's case would take.
Thank you. So we'll stand in our recess, ladies and gentlemen, until 11 o'clock. Defense has an opportunity to argue its motion for judgment of acquittal. That motion was filed yesterday, February 20th.
Yes, and I'll note that originally we thought the state would complete yesterday. So even though it's dated yesterday, it's to take effect at this point now that the state is rested.
Thank you.
I move for the court to grant the judgment of acquittal on each of the present charges, each count separately, and I will just go through each of them. The state has presented, and again, the standard for a motion for judgment of acquittal, is there any evidence that the jury could find beyond a reasonable doubt that the state has met its burden on each and every element of the offense charge. Let me just begin where I will concede that there is sufficient evidence of certain elements that would have to be resolved by the jury. So for example, I believe the state has been able to show that a jury could find that Jennifer Dulos is deceased. We would also concede for purposes of this motion, that the death of Miss Farber Dulos was either induced by or caused by Fotis Dulos, either directly or indirectly. What I submit that the state has failed to establish is whether that death was caused by the specific, under the common law, we call malice aforethought, which means intentional killing of another individual under the statute providing for the elements of murder. That, however, even if the state could do that, even if the state can argue that there's sufficient evidence to show that Fotis Dulos planned the outcome that occurred, we have to also remember, Your Honor, that much of the state's evidence is based on this presumptive testing, which I note under State versus Moody, in and of itself fails to provide any evidentiary value whatsoever. So even though the jury and the court hasn't yet fully instructed the jury, the court made some comment to the jury about what it's allowed for. But luminol and Castle-Meyer are not evidence of blood. So the fact that there's been a lot of testimony about that, it's in the interrogation videos, it was the subject of many witnesses' testimony. It does not provide any basis for the court or for any fact finder to determine that that was in fact blood. And for reasons that we still don't know, there are only three items that were tested, and we concede one of them being the shirt and the other being the bra. I forget what the third one is right now, but there was one other place where they did test, and it was determined to actually be not just a blood-like substance or something that tested under a presumptive test, but was in fact blood. The problem with the state's theory of this case, and as it was presented, is that the state spent a month or more trying to prove that Fotis Dulos killed his wife. None of that, however, none of that evidence pointed to Ms. Troconis as being a party to that plan, that design, or the acts involving the death itself, or the cover-up afterwards. I would readily concede that the court proved that Fotis Dulos was involved in the covering up of a crime, whether that crime was murder, as the state alleges, or some other crime. Again, the way it's been charged, that it could only be murder. It cannot be manslaughter. It cannot be a reckless death during a fight or struggle. It has to be murder because that's the way the state charged this offense under count one. In fact, the way they charged it is they say that Fotis Dulos, quote, did assault Jennifer Farber Dulos in her home on the 24th day of May, 2019, with the intent to restrain and kill her in violation of sections 53A, 48A, and 53A-54A, subsection A. I will note there has been no evidence from any source of any restraint, but let's just assume that there's still enough to at least allege that there was an intent to kill, even if I submit the evidence doesn't support that. But now we get to the question in count one of conspiracy. Under our law, under Connecticut General Statute 48A, the state must demonstrate essentially four things. One being the underlying purpose being to restrain and kill Jennifer Dulos. The first question is they have to prove that Michelle Troconis intended to commit that crime, the specific crime of murder. Two, that there was an agreement between Michelle Troconis and Fotis Dulos to commit that crime of murder. Three, that the specific intent was to restrain and or kill, not or, Jennifer Dulos. And four, there was an actual agreement to do those things together. Now, the state has alleged that the defendant agreed with other persons, quote unquote, to engage in these crimes. The state is not required to actually place in their information who those other people were. We've heard the names of possible other individuals. There was Kent Mawini. There was Andreas Tutsiartis. There was even Pavel Gumieni as people that may have committed acts that might be considered certainly suspicious, but the state made no effort to demonstrate that Michelle Troconis agreed with any of them to commit an offense. I now want to just talk about the count. Basically, I'm going to not repeat what I'm saying about the crime of conspiracy, other than conspiracy is a specific intent crime. Not only do you have to prove the underlying elements that the defendant was involved in, but that she had a specific intent to agree to commit those offenses in advance. And if one looks at and I'll start with count two. Count two specifically alleges that Michelle Troconis entered into a conspiracy on 24th of May, 2019, in the area of Albany Avenue in Hartford, to commit the crime of tampering with physical evidence with the intent that conduct constituting that crime be performed, did agree with Fotis Dulos to engage in and cause the performance of that conduct. And one of them, I would submit, the only other one is Fotis Dulos, did commit an overt act in furtherance of the conspiracy. It goes on to say that Michelle Troconis traveled with Fotis Dulos to the Hartford area for the purpose of disposal of physical evidence relating to the murder of Jennifer Farber Dulos in Hartford on May 24th, 2019. That's the allegation that's been submitted. I submit there is no knowledge, no evidence whatsoever that Michelle Troconis either agreed to do that or had any idea what was going on, what Mr. Dulos was doing. We've spent, I don't know how many hours of interrogation video. She never, so we start with the fact she said absolutely nothing that would constitute admission to any knowledge of that. To the contrary, she repeatedly, over the course of months, denied any knowledge as to what Dulos was up to. So what is the evidence with regard to that? We do know, let's work backwards. The police did not come to the home of Dulos and Mr. Troconis until approximately 8:30 the night of May 24th, 2019. The testimony is they came to the house and told Mr. Dulos, and my client heard part of this, that Jennifer Dulos was missing. This, of course, is after they were in Hartford on Albany Avenue. So we have black garbage bags, opaque garbage bags. We see Mr. Dulos placing them in various receptacles. Only one of them, incidentally, contained any items of evidentiary value to this case. The ones where the two garbage bags, the shirt, the bra, a number of other items that were found with blood on them, they weren't in garbage bags. It was spread among whatever trash was in that barrel. But be that as it may, the evidence is uncontested that it was Fotis Dulos who got out, took the garbage, and threw them in those barrels. This is prior to any time that Michelle Troconis would even know that there was a crime that may have occurred and that there was an investigation that was beginning. So in order to be guilty of tampering with physical evidence, it specifically requires under the statute, under 53A-155, that the defendant would have to believe that a criminal investigation conducted by law enforcement or is pending or about to be instituted. And it claims that she either destroyed, concealed, or removed anything for the purpose of impairing its ability to be used in the criminal investigation. Again, the only evidence is that she only even learned that there was an investigation afterwards at 8:30 at night, after they had been to Albany Avenue, after they'd been to Starbucks, and then they went home. So I submit that there is zero evidence in the record to allow any reasonable trier of fact, to conclude that she engaged in that conduct or agreed in advance to that conduct, either substantively or in a conspiracy to commit that crime, in the absence of any evidence that she knew there was a criminal investigation at all, or that even one was being instituted. If I may move on. I will also note, Your Honor, that there's a lot of cases that specifically say that mere presence or even acquiescence in the conduct of someone else is not evidence of a crime. And a jury has to be instructed that that cannot be used as the basis. There has to actually be affirmative evidence. Merely being present under our law is not a basis to convict anyone of any crime, even if they're sitting there while someone else is engaged in obvious activity in their presence. Count 3 is the substantive offense of tampering with physical evidence, again under 53A1, 55A1. It is charged as accessory under 53A-8. I note that under our law, the crime of accessory and the principal crime are the same. They are two manners of committing the same crime. But the way it's been charged here, it indicates that simply that she committed the substantive crime. I guess there's zero evidence that she did that. She didn't touch anything that's connected to a crime in the city of Hartford on May 24th, 2019. I will note, Your Honor, I'm anticipating what the state's going to say. Well, there were 3 cells of partial DNA of Mr. Troconis found on the exterior of the opening of the bag. So the place where you would hold it, you grab a bag, might pull it out of a box, but it was partial. And the state did not test either Mr. Troconis' mother or her daughter who also lived in the home, even if they can assume that these garbage bags came from that box of trash bags that was seized from the home itself. There's an interesting recent Connecticut Supreme Court case on this that Your Honor should be at least aware of that I want to cite. State versus Dawson at 340 Connecticut, 136, 2021. That is a case where there was a firearm discovered where there were in the immediate vicinity of 3 or 4 individuals. And the Supreme Court in that case ruled in 2021 that DNA evidence standing alone does not establish that the defendant had dominion or control over that weapon. So they reversed the conviction saying the presence of DNA, and they went into this issue of partial DNA, the number of picograms, the idea of transfer DNA. They say that is not enough to convict anybody. And I submit that that is precisely where we're going with this particular case here, and the suggestion that 3 cells that are a partial match to Mr. Troconis cannot be the basis for such a finding with regard to that charge. Now let's move then to counts 4, 5, and 6, which all relate to the Russell Speeder car wash in Avon, which is where the state alleges. So we're talking about we're talking about what happened in Mountain Spring Road. That is not the charge. The fact that Mr. Dulos handed Ms. Troconis a paper towel that did not smell like anything that she put in a garbage bag is not what they're charging here. It's according to the way this case was charged. It says that she both tampered with and hindered the prosecution by, did agree with Fotis Dulos by transporting the 2001 Toyota Tacoma used in the commission of the murder of Jennifer Farber Dulos to Russell Speeder's car wash for the purpose of having evidence relating to that murder concealed and destroyed. The count 5, tampering, specifically indicates that believing that the criminal investigation was pending or about to be instituted, altered, destroyed, concealed, or removed a thing with the purpose of impairing its availability in the criminal investigation. And finally, under hindering, it render criminal assistance, as that is defined, to another person that she believed committed a murder. I mean, it specifically committed a Class A felony, to wit, murder, did provide Fotis Dulos with transportation and other means of avoiding discovery and apprehension. Well, even that is baseless here, Your Honor, because she did not provide transportation to Mr. Dulos to bring the vehicle there. The only testimony is that she followed outside in a separate vehicle, I guess on May 29th, which is what the allegations are here, and then picked him up at the car wash. The only reasonable interpretation is she was somewhere outside, not even visible. He had to call her on the phone to come get him. And of course, this is after the vehicle has been brought in. And then the testimony is they then together drove down to Attorney Bowman's office in Westport. And then when he came back, we had the video. Mr. Dulos obtained some cash and went inside, paid for the detailing after it was done. There is no evidence that Mr. Troconis had anything to do with that. There's no evidence that she had any involvement in that bank account, that she even would have known what he was taking out and for what purpose. He went in alone to have the car detailed and washed. He alone went in to have it, to pay for it after the fact. And I just want to also clarify, because it took a little bit. So we got Detective Clabby yesterday to admit it. I'm sorry, Detective Kimball to admit it. But even Mr. Dulos did not falsely give information about the Toyota Tacoma to the aide, that in fact, the employee had mistakenly written the phone number on the line of a vehicle that came at 8:44 in the morning, and then rewrote it on the line below where it didn't indicate the name of the person who was bringing in that vehicle. So, I don't need to repeat, for each of the crimes, you have the same elements. For hindering, all requires specific intent. They have to specifically show that the purpose was to commit specifically a crime, a Class A or B felony, that she had to be aware of that. In this case, it had to be, by the way the case was charged, murder, not any other crime, not any other crime. There's just one other, and I'll note when I refer to the log sheet, Your Honor, I'm referring to State's Exhibit 138, the Russell Speeder log that was introduced, in which I showed as well to Mr. Kimball yesterday. I just want to have a moment. I know that, and I'm just going to say this for the record, I know that Judge Lowry denied this, but I want to incorporate my arguments about vicinage and venue for my judgment of acquittal in the case that vicinage is a requirement of the location of the crime. And that all of these crimes, all of them, including the conspiracy, all occurred in the Hartford Judicial District. I stated for the record, I'm not asking the court, well, I would ask the court, I don't want the record to suggest that I've waived the issue. So I raise it now so that the court is aware that I'm making that also part of my judgment of acquittal argument at this time. Let me just look at my notes for a moment, Your Honor. When I made the comment about mere presence as an inactive companion, passive acquiescence, or the doing of innocent acts, which may in fact aid the one who commits the crime, must be distinguished from the criminal intent and community of unlawful purpose shared by one who knowingly and willfully assists the perpetrator of the offense in the acts which prepare for, facilitate, or consummate it. That's from State versus Enano, which goes back to 96 Connecticut 420. It's also cited in State versus Pundy, P-U-N-D-Y at 147 Connecticut 7, where the court went on to say that those who simply are companions in passive acquiescence may be said to be innocent of any wrongdoing. Just want to check my notes one more time. I'm just going to mention in case the state, instead of standing up a second time, I'm going to just mention Pinkerton liability in case that's one of the state's arguments. That doesn't apply here. And I will note that under Pinkerton, such cases as State versus Bennett at 307 Connecticut 758, which cites to the Pinkerton decision at 328 US 640, require a community of criminal intent and community of unlawful purpose with the perpetrator of the crime, and must be knowingly and willfully done to assist the perpetrator in the acts which prepare for, facilitate, or consummate it. Under those cases, Your Honor, and there's numerous cases that now deal with the Pinkerton liability, that applies when if somebody is going to rob a bank and they conspire in advance to rob the bank, and there's evidence of that conspiracy, but one of the co-conspirators pulls out a gun and either shoots someone or at least threatens the gun. Co-conspirator can say, well, I didn't know he had a weapon. But under Pinkerton liability, if it's within the furtherance and it can be believed to be a likely alternative or outcome, that could happen if you're going to rob a bank, there's an inference that it may be probable somebody may be armed. You can be held liable to the more, what's the best way to put this, to the enhanced penalties or the aggravating factor that would be contemplated within the crime accused, but you have to go back to knowing what was happening in the first place. If you go to the bank, for example, to make a deposit and the person you're with robs the bank, pulls out a gun and robs the bank, if there's no evidence of an agreement, you're there just to make a deposit, that could not then subject the person to Pinkerton liability merely because he or she was present. In other words, it doesn't shift that liability and do away with the requirement of concert and concerted effort and agreement to commit the crime.
Well, the touchstone of Pinkerton is foreseeability, correct?
I'm sorry, Your Honor.
The touchstone of Pinkerton is foreseeability.
Foreseeability, yes, Your Honor. And of course, and I also, when I read Pinkerton, it's not only just foreseeability that one of the people will do something else, but you are already committing a crime. It is not foreseeable that if you go into the bank, a friend of yours may commit a robbery. It's that you agreed in advance. It's just that it's foreseeable that maybe that other person that you already agreed to commit the crime with did something more egregious than simply ask for money and hand up a note. So that's the claim that I'm making with regard to that. There was just one other point, Your Honor, that I wanted to make before I sit down. I'm just going to ask the court, there are a couple other cases that have come out that I wanted the court to look at on the issue of with tampering, for example. And they are State versus Knox, K-N-O-X, 201 Connecticut, appellate 457 in 2021. And they talk about State versus Jordan, which is in 2014, 314 Connecticut, 354. They talk about that that's where it specifically says, even though the statute is not as clear, that you had to have acted with the intent to prevent the use of the evidence at an official proceeding or criminal investigation. And it construes in that respect the difference between that case and State versus Forshaw, Foreshaw, at 214 Connecticut 540, where there was some debate between whether it was a requirement or not. And I submit the Jordan case and then the Knox case make that clear. I also want to make one other last argument here. There is going to be some evidence suggested by the state that if Ms. Troconis made false statements or intentionally made false statements, which of course we dispute, but let's assume that based on the testimony, the jury could find that she made false statements during the interrogations. That evidence, Your Honor, was admitted for purposes of arguably consciousness of guilt. And we will be submitting a jury instruction that they have to first find that it was intentionally false as opposed to based on either mistake, misremembering, being coerced, all those things that we've talked about. But the case law on consciousness of guilt makes clear, and the judge must instruct the jury, that consciousness of guilt is not evidence of the crime itself. So they would have, the state would have to prove separately that the defendant, that there was sufficient element of crime in each element of the crime, and then apply whether, I'll use flight as the example. If a person runs away when the police come and somewhere in a group of people they find drugs, that fact of somebody running away is not evidence that the individual possessed those drugs or possessed it with the intent to sell. It's admissible to show a guilty conscience. And that would only be admissible if there was separately sufficient evidence of the underlying crime beyond reasonable doubt or crimes. Just one moment, Your Honor. Oh, the other case on Pinkerton that I wanted to cite was State versus Patel, which is the appellate court case 194 Con App 245, 2019. And then I'll also cite to the elements for conspiracy to commit murder, State versus Balbuena, B-A-L-B-U-E-N-A, which is 168 Con App 194, 2016. And conspiracy to commit murder, State versus Pinnock, P-I-N-N-O-C-K, at 220 Connecticut 765. Based on that, Your Honor, I asked that on each of the counts. I'm sorry, I thought I was done. I realized one other thing. There are 3 separate conspiracy charges charged here. I submit that the state has not shown any 3 separate agreements under any theory. And at the very minimum, the court is required, based on the evidence, to grant the judgment of acquittal as to 2 of them. And the way I understand the law, the court can leave in the most serious one, which would be the conspiracy to commit murder if the court does not agree with my other arguments. But the court must, based on the case law on the issue of a multiplicity of charges, they have not shown there were separate conspiracies at any time, haven't shown any conspiracy at all. They certainly haven't shown there are separate conspiracies. And based on all of that, Your Honor, I ask specifically, just on this last argument, that the court grant the judgment of acquittal as to count 2, count 4 as a separate argument. Thank you.
Thank you.
Your Honor, good morning, and may it please the court. Your Honor, the defendant's argument seems to be that we have a different interpretation of the evidence and therefore grant us an acquittal. But of course, as the court knows, that is not the standard that the court needs to apply here. The court has to view the evidence in the light most favorable to the state as part of this motion, including drawing all reasonable inferences that a jury could find in favor of guilt. Thank you. Including drawing all reasonable inferences that a jury could find in making a finding of guilt. So I want to just begin with the argument that the state has proven that Mr. Dulos is responsible for Jennifer Dulos' death, but that somehow the state has not presented sufficient evidence for a jury to find that it was actually an intentional killing. That is completely belied by the facts of this case, Your Honor. A reasonable jury can draw the following inferences. Number one, Mr. Dulos was motivated to harm Jennifer Dulos based on the fact that they were involved in a highly contentious divorce. Mr. Dulos drove his employee's Toyota Tacoma to New Canaan to commit this crime. He attacked Jennifer Dulos in her garage and killed her with at least 2 blows. It's been about a month, but you'll recall, Judge, we had the blood pattern expert who came in and indicated that there were at least 2 blows which were delivered in this case based on the direction of the blood pattern. By the way, the fact that he was in New Canaan in the first instance, Your Honor, is evidence of his intent because he had no reason to be down there. The children did not have visitation on that day, and the fact that he went down there in the first instance is evidence of his intent, including the fact that he took his employee's vehicle. State versus Moody does not stand for the proposition that the defense keeps citing. State versus Moody, or I know the court knows this, but it's the totality of the evidence in this case that is the dispositive factor, including the fact that all of those presumptive blood tests subsequently tested positive for Jennifer Dulos's blood. So that's the compelling factor in this particular instance. A reasonable jury can also find that Jennifer Dulos was transported from her home by Mr. Dulos and her body was disposed of in some manner, which again goes to the intent in committing the crime in the first instance. A reasonable jury can find that her clothing was removed by Mr. Dulos and disposed of in the trash on Albany Avenue, thus demonstrating his connection to the blood, the clothing, and his act of murder. And I would just cite the court to State versus Richards, 196 Conap 387. The state does not need to prove the cause of death in a murder case merely that it was caused by criminal means. So in other words, the fact that the body has not been recovered does not mean that a jury can't find that there was homicidal violence in this case, particularly when you combine the blood pattern evidence with the cut clothing, with the fact of animus towards Jennifer Dulos and Mr. Dulos's DNA in a mixture of blood with Jennifer Dulos's DNA on that faucet. Now, counsel will say, well, there was no confirmatory test done. That's not the test. It's not whether or not a confirmatory test was done. The test is whether or not a reasonable jury could find. So here you have Mr. Dulos's DNA mixed on the faucet with Jennifer Dulos's DNA. It's a blood-like stain that tests positive for blood, which is strong evidence of his guilt. Now, that is, of course, evidence of Mr. Dulos's intent, but let's talk about the evidence of the defendant's intent. I would direct the court to State versus Soini, 180 Conap 205. That was a conspiracy to commit murder case, and the court in Soini specifically talked about one of the factors, of course, for a jury to consider is whether or not somebody who is alleged to have entered into a conspiracy would have been motivated to enter into that conspiracy. So let's talk about all the evidence of the defendant's motive that the state has established during the course of this case. And I would just note also that there is no requirement in a conspiracy case that the state present a witness who comes in and says, I agreed or I heard an agreement. It can absolutely be proven by circumstantial evidence based on the fact that conspiracies by their very nature are done in secret. And there's a whole line of cases, Your Honor, that stand for that proposition. So the evidence of the defendant's motive here, obviously, number one, her boyfriend is in a contentious divorce with Jennifer Dulos at the time. In part, incidentally, due to the fact that the defendant and Mr. Dulos had an affair and Jennifer Dulos left the house shortly thereafter with the children. They were in a custody battle that necessitated the defendant having to leave the home whenever Mr. Dulos had visitation. She was not to be allowed around the children. During her interview, the defendant actually said that this had been 2 years of torture. She talked about applying for a restraining order against Ms. Dulos. She discussed the fact that her relationship with Mr. Dulos was suffering as a result. And in fact, the defendant told Mike Meehan that she had not moved to Connecticut for this. The defendant also told investigators that she was prepared to leave Mr. Dulos as early as December 2018, and the jury can infer that she was going to leave because of the fact that this divorce proceeding was driving a wedge into her relationship with Mr. Dulos. The defendant was obviously, a jury can infer, extremely upset and motivated to harm Jennifer Dulos, as evidenced by the fact that she stated, when referring to Jennifer Dulos, that that bitch should be buried next to the dog, thus demonstrating severe animus towards Jennifer Dulos and explicitly referencing her death a month or so leading up to Jennifer Dulos's disappearance. And even after Jennifer's disappearance, the defendant's animus towards Jennifer Dulos continued, as evidenced by the fact that she told Pavel Gomini that she was going to, quote, kill Jennifer when she turned up. Now, the defense will say, well, that proves she didn't know. The jury doesn't have to accept that. The jury can accept that as merely a self-serving statement in an effort to cover up her involvement in the crime, but while still expressing severe animus towards Jennifer Dulos. The jury can also infer, Your Honor, reasonably that the defendant had advanced knowledge of the murder and actively tried to help Mr. Dulos with his false alibi. After all, the defendant was home at the time or the approximate time of the murder, and purposely, the jury can infer, answered his phone to help establish his alibi, as evidenced by the fact that Mr. Dulos wrote in his alibi script that he initially answered the phone. The phone call, of course, was from Mr. Dulos's friend, who subsequently refused to cooperate in the investigation, and that call, according to the data, had been arranged the day before. The defendant, of course, did not mention this call in her first two interviews, and in fact, indicated in the second interview that she had not seen Mr. Dulos's phone at all. The defendant actively lied about Mr. Dulos's whereabouts on the morning of the crime, even after being told that Mr. Dulos was responsible for Jennifer Dulos's death. And the evidence is, if Mr. Dulos was in New Canaan killing Jennifer Dulos, which the defense has essentially conceded, although they don't concede the intent, that the defendant was home alone with Mr. Dulos's phone and manipulating it. That's the evidence. She's unlocking the phone. She's playing with the phone at times when Mr. Dulos is in New Canaan. And that, again, is something the jury can draw a reasonable inference that this whole thing with the phone call was a planned event. The defendant was in possession of his phone, waiting for the call that had been prearranged the night before. The jury can also infer, Your Honor, consciousness of guilt based on the fact that the defendant actively assisted Mr. Dulos in attempting to conceal evidence of the crime, thus demonstrating a consciousness of guilt with respect to the conspiracy to commit murder. And that, of course, serves as the basis for counts 2 through 6. The defendant incidentally says that the court at this point needs to make a finding that it was one conspiracy. They cited no case for that proposition, Your Honor. It's just simply false. A reasonable jury could reject some or all of these counts, and it's up to the jury to decide whether or not the state has proven each element of each crime beyond reasonable doubt. They cite no case for that proposition whatsoever. But nonetheless, those counts. The defendant, I guess, was claiming that because the state didn't indicate evidence of others being involved in the crime. Number one, that's not true, because we have the testimony regarding Mr. Dulos' friend making the phone call, not cooperating, but also not required for conspiracy to commit murder. The only thing we have to prove, Your Honor, is that she agreed with one or more persons. That's the state of the law. So it's false to say that we somehow had to prove that she conspired with other people besides Mr. Dulos. With respect to the tampering counts, Judge, we have charged her under an accessorial liability with respect to that. The test is essentially that the defendant believed an official proceeding or criminal investigation was pending or about to be instituted, helped Mr. Dulos discard the evidence at issue, and acted with the intent to prevent the use of evidence at an official proceeding or criminal investigation. I'll direct the court to State versus Forsaw, which is 214 Con 540. In that case, evidence that the defendant had discarded a murder weapon before any contact with police officers or the judicial system was sufficient to convict the defendant of tampering with evidence. So there's no requirement, Your Honor, that actually an official proceeding ever begin or the timing of it, merely that the defendant believed one was about to be initiated. So what can the jury find with respect to counts 2 and 3? A reasonable jury could find the following: that the defendant agreed to assist Mr. Dulos in the destruction of physical evidence and assisted him based on the following. She was present at 80 Mountain Spring Road shortly after Tacoma arrived and drove back and forth several
Your
times.
Honor, I apologize. The state may interpret have a moment. We're having a technical issue.
Certainly. May I proceed?
Yes.
Thank you very much.
A reasonable jury can find that she was present at 80 Mountain Spring Road shortly after the Tacoma arrived back and after this crime was committed, and that she drove back and forth several times. A reasonable jury can find that she believed a police investigation was about to begin and that she was actively helping Mr. Dulos, as evidenced by the fact that she brought cleaning supplies. A reasonable jury can find that she accompanied Mr. Dulos to Hartford and was present as he disposed of those items, and that she actually assisted him in the disposal of the license plates by opening her door at the exact moment that he opened his door and left it open until he dumped those license plates in the sewer. If you look at the video very carefully, Judge, what you're going to see is a vehicle there that she's attempting to block, and a reasonable jury could make that finding. She's trying to block the view of that particular vehicle. A reasonable jury could find she was aware of what was in the construction bags, as evidenced by her many lies about the entire day, including the fact that she was present at 80 Mountain Spring Road and was going back and forth repeatedly and apparently lighting fires, which is again consistent with the destruction of evidence. She actively assisted in the cleanup process prior to going to Hartford, including bringing cleaning supplies, which incidentally were consistent with those which were found in Hartford, including a green and yellow sponge, a broom or a mop handle, and black garbage bags, all found in Hartford that the defendant admitted to bringing to 80 Mountain Spring Road. The defendant's DNA is located on the opening of a bag that tested positive for blood, had Jennifer Dulos' DNA, and had duct tape, and was found amongst other bags matched to Jennifer Dulos' untimely death, specifically a bag that contained a bloody shirt and bra confirmed to be human blood that was forensically linked to the DNA of Jennifer Dulos. With respect to counts 5 and 6, Judge, a reasonable jury can find that the Tacoma was used in the commission of this crime, and the defendant assisted Mr. Dulos in his effort to conceal evidence found within and upon the Tacoma. As the court knows, the Tacoma was viewed on video surveillance leaving 80 Mountain Spring Road in the early morning hours. It was tracked on surveillance footage heading down to the New Canaan area, It was parked near Waveney Park in the general area where Jennifer's Suburban was found. Approximately 40 minutes or so after Jennifer's Suburban was viewed leaving her residence, the Tacoma was seen traveling north on the Merritt Parkway, where it essentially tracked right back to 80 Mountain Spring Road. A reasonable jury can conclude that evidence relating to the crime of Jennifer Dulos was inside of that vehicle based on, number one, her blood being present, and yes, they can make that finding on one of the seats. The defendant's acknowledgement that Dulos was cleaning the vehicle, and Dulos's paranoia and insistence that Mr. Gamini get rid of the seats from the Tacoma. Moreover, a reasonable jury can conclude that the defendant was at 80 Mountain Spring Road during the cleanup of the Tacoma, and in fact admitted to assisting Mr. Dulos throw away a paper towel that apparently was being used to clean the Tacoma. The fact that she says it's coffee is not dispositive. The jury can merely view this as a self-serving statement, especially in light of all the other evidence in her lies. The defendant took the keys to the Tacoma, and a reasonable jury can conclude that she took the keys to the Tacoma because she understood that Mr. Dulos had used it in the commission of the crime, and they wanted to keep the Tacoma in Farmington so that they could continue their efforts to clean up. The defendant drove in tandem with Mr. Dulos to the car wash, knowing that he was going to wash the car in an effort to conceal evidence of the crime. Again, a reasonable jury can make that finding, especially given that she initially tried to sort of fudge those facts to the police and lie about it and say that he'd called her to come pick him up. And then when she's pressed, she says, oh, well, maybe we went together. The Tacoma was extremely clean when it was found by investigators. So clean, in fact, that despite the fact that it was an 18-year-old work vehicle, there were numerous places where there was no DNA profiles at all, thus showing evidence of the destruction of evidence in the cleanup. DNA expert Kristen Maydell testified that DNA can be destroyed by wiping it or using water or shampoo. Thus, a reasonable jury can conclude that there was evidence destroyed in connection with this case. The defendant also showed consciousness of guilt with respect to this by not telling investigators that the Tacoma was at 80 Mountain Spring Road, thus demonstrating her understanding that this was used in the commission of the crime during her first two interviews. The defendant also failed to tell the police that this vehicle had been washed during the first two interviews, again demonstrating consciousness of guilt. With respect to the hindering count, Your Honor, obviously, the defendant, by following Mr. Dulos out, meeting him at the car wash, and a reasonable jury can infer that she understood that the crime of murder had been committed. Incidentally, this is 5 days later, but certainly, Judge, a reasonable jury can infer based on all the evidence that she understood that that vehicle was evidence of a crime. And she picks him up and provides transportation, essentially through the use of her vehicle, back to the car wash so that these things can be done. And she also, coincidentally, her phone number is the number that is used on the call log, which again, a reasonable jury can view as an effort to distance Mr. Dulos from the car wash. Perhaps they thought that she wasn't under investigation, even if he was. And again, a reasonable jury can make all of these findings. So, Your Honor, again, this isn't a motion about we have a different interpretation of the evidence. That's what closing argument is for. The question for this court is, has the state presented sufficient evidence to proceed? And of course we have, Your Honor, based on our argument. Does the court have any questions?
Yes. The court is reviewing the information that the court read to the jury. That information was filed on or about October 5th, 2023. The court is reviewing count 5.
I apologize, Your Honor. I don't have a copy in front of me. If I just... Sure, thank you.
And the information reads, the court is just going to read the pertinent part. On the 29th day of May 2019, in the town of Avon, in the area of 265 West Main Street, that being Russell Speeders, the defendant, Michelle Troconis, believing that a criminal investigation conducted by a law enforcement agency was pending and about to be instituted, and an official proceeding was pending and about to be instituted, did alter, destroy, conceal, and remove a thing with the purpose of comparing its availability. What evidence did the state introduce on that count?
Yes, sir. The evidence is the car wash itself. And if I may just be heard on this, because I did hear Attorney Schoenhorn's argument, but we charged her as an accessory in this particular count, Your Honor. And I know that I didn't think that this was going to be an issue, but I'm happy to provide the court with the case law. But essentially, by putting the accessory statute, we put the defendant on notice that that is a theory that we are pursuing. And so the court needs to view that count in light of that allegation that she was an accessory. And so the fact that the Tacoma itself was brought to the car wash, if a reasonable jury can infer that the Tacoma itself was used in a crime, then the jury can infer that she aided Mr. Dulos in the tampering of that evidence by providing him with transportation, by allowing her phone number to be used, and that the destruction of evidence happened. So there is no requirement, Your Honor, based on the way that we've charged this, that we prove that she actually altered the evidence herself, because we've charged her under an accessorial liability theory.
Thank you.
Very briefly, I just want to respond to a couple of things. I'm actually a little surprised to hear Mr. McGinnis say that the luminol was tested and confirmed to be blood on all these items. That's simply untrue. There were 3 items total that were tested. None of the others were tested. This all goes back to the suggestion they can infer it was blood from that is not only improper, but I submit that if they argue that point to the jury, that's considered prosecutorial misconduct based on that. So I submit that that's just a erroneous statement. With regard to the bald assertion that Mr. Dulos was in New Canaan that day, and so therefore he wasn't home, I submit there's no proof of that. We concede he had something to do with a plan, but they cannot prove that it was Mr. Dulos who was there on May 24th, in light of the fact he was there on May 22nd. And therefore, they cannot, as I cited, I don't even hear the state referring to that recent Connecticut Supreme Court case on DNA that I just cited a few minutes ago. So, and about transfer DNA. But be that as it may, there is not evidence that all of these other items were tested and found to be positive for Jennifer Dulos's blood. If there's evidence of homicidal, let me rephrase that, evidence of a homicide, that does not prove intent. It doesn't improve murder. It improves an untimely death. And a motive, even if a motive exists, is not equal to a conspiracy. There may be a lot of people that you might wish ill will to, but in the absence of either knowledge or actual overt action, it doesn't translate that into finding, well, if you don't like somebody, that's the motive to kill them. The argument that she, quote, actively concealed, unquote, evidence of the crime is also completely speculative and made up. The fact that there was a fire in a fireplace during the afternoon, the suggestion they can say, well, she must be burning evidence of a crime. She must know that there is a crime being committed, that therefore the fact that there's a fire in her fireplace is proof of that. I submit would be pure speculation. In fact, half of what I just heard is speculation upon speculation upon speculation. I would note that Mr. Kumieni, for example, did not identify the red truck that was on the side of Latham Road as being his. The only time he identified a vehicle as looking like his was somewhere on the Merritt Parkway. There's the one angle from the rest stop on the, and I can't remember as I'm standing here whether that was Fairfield or New Canaan, but I believe it was Fairfield, where he said yes, because it has that bar in the front. We recognize that. None of the others are identified by Mr. Kumieni as being his vehicle. So I submit there is no evidence that that's the truck on the road. What's more important and kind of interesting, Your Honor, there's no evidence of when the Chevy Suburban ended up on Latham Road until 8:30 p.m. when it was discovered by the police. There is zero evidence it was there during the day. There's no vehicle, there's no one who passed by that saw it. There's no cameras from any buses that show it there at any other time. And we do have evidence that that a phone that's been paired to that, that vehicle since 2018, and which the evidence shows she was going to see Dr. Geronimus. So that is her phone. The state objected to my asking Ms. Farber about that, but it's obviously clear in light of the testimony that that phone was Jennifer Dulos's phone paired to that vehicle at 2:56 p.m. on the afternoon of May 24th, 2019. And the state concedes that Mr. Dulos was in Farmington at least 1 o'clock or so on that afternoon of the 24th. The idea that, I'm not sure, I may have misunderstood Mr. McGinnis, so I apologize in advance, that he said that that they don't have to show who these unnamed speculative co-conspirators were. I don't know if he said that they didn't have to show which one of them she conspired with, or he said the opposite, that they don't have to name other people as long as they prove beyond a reasonable doubt that she conspired with Fotis Dulos. I also submit, Your Honor, because I prepared for that the state misread and misstates the holding in State versus Forshaw, which I also cited. In Forshaw, the defendant actually shot someone in the presence of numerous witnesses, then fled, then got rid of the weapon. In that case, the Connecticut Supreme Court held that it was obvious that there would be a criminal proceeding that was going to be commenced because she knew there were witnesses, and the fact that she fled from it was it was obvious to anybody that there would be a criminal proceeding pending. We're talking about here, what's basically hindsight bias, hindsight creation of what someone should have figured out after the fact based on what was happening at the time. At the time, there was no evidence whatsoever that Michelle Troconis knew what Fotis Dulos or anyone he conspired with or aided did to Jennifer Dulos on that day. And there's also no evidence. She did not provide, this is also clear, she did not provide transportation to Mr. Dulos to go to the car wash. She was going to an appointment with her lawyer, and she picked him up at the car wash and brought him down to Westport with her, and he drove. That's the only evidence that's in this case on that point. Finally, there was no evidence of blood. I want to be clear in that Tacoma. None. There's no evidence she cleaned the Tacoma. She didn't even see Dulos cleaning the Tacoma. All she knows is he handed her a paper towel, said that he had spilled coffee, handed it to her, and she put it in a garbage bag. Whatever he was doing inside that Tacoma, there was zero evidence that she saw him. In fact, Pavel knew what he was doing. Pavel was told by Dulos that there might have been a hair of his wife in there, so he wanted him to take out those seats. So if anyone had knowledge that there may be evidence of a crime in there, it's Pavel Gumieni and not Michelle Troconis. The only difference, I guess, is that Mr. Urzo, Attorney Urzo, representing Mr. Gumieni, had the wherewithal and obtained immunity in exchange for cooperation. That's something that Ms. Troconis did not ask for and did not receive. And that's the only reason I submit she's sitting here today. The only reason she's sitting here today. The state talks about, well, we charged her, the court had a question about the tampering at Avon, at the car wash. They said, well, we charged her as an accessory to alert the defense. But again, you have to act with the exact same state of mind. So the leap of logic that the state is asking this court to jump to, or for that matter, the jury to come to, she must have thought there was some evidence that would lead to a criminal prosecution or a criminal proceeding because she picked him up. She left at the same time, but that she picked him up at the car wash, and we don't even know what time that was. We just know the approximate time that the call went in to pick her up, for her to come get him. But she wasn't even within range that he could just jump into a car and leave. He had to call her on the phone. And the one last thing that I think there's absolutely no evidence, and it's also, again, improper. Mr. McGinnis just said that the defendant allowed her phone to be used at the car wash. That is simply, definitively a false statement. There is no evidence she allowed her phone to be used by Mr. Dulos when a number was written down by the car wash employee. And if your court will recall, just a couple of days earlier, Mr. Dulos's phone, his regular phone, had been seized by the police. And it is just as likely, not just as likely, is extremely likely that at that moment, he didn't know the phone number, the one that he was now using. So he used one that was in Ms. Troconis's possession when they went down, when they were about to go down to Attorney Bowman's office. So based on that, Your Honor, I tried to respond to the arguments. I'm not going to fight or even contest the fact that there was some kind of untimely death that the jury could find was based on this evidence. I'm just submitting that there is not the evidence that was just submitted by Mr. McGinnis, and the idea that one could put assumption upon assumption on speculation upon speculation and reach that conclusion based on this evidence is not even warm rule. It is absolutely, there is no logical inferences that could be drawn that could lead to the conclusion that Michelle Troconis knew anything about what's either happened to Ms. Farber or what Fotis Dulos was doing in a criminal conduct in relation to her disappearance. Thank you.
Just quickly, Judge, counsel completely misstates the state's position on these things. What I've said is that a reasonable jury can draw these inferences. Not that these things are definitively in the record at this point. Obviously, a reasonable jury can infer that the defendant allowed her cell phone to be used as evidence in the totality of all the evidence. So he misstates it. I also never said that all these items were tested positive for blood. I don't think I even used the word luminol in my argument. So I guess we're just making things up now as we argue to the court. But I did just want to follow up on the one issue, Judge, State versus Vasquez, 68 Conap 194 on the accessory liability issue. I just wanted to give the court one case. I didn't have a chance to research all of them. Just on that count 5 issue.
Thank you. The court will just begin by indicating what the court has to find in a motion for judgment of acquittal. Of course, the court does not have to determine that the state has proven each and every element of each and every offense beyond a reasonable doubt. That's the province of the jury. Court has to determine whether there is sufficient evidence on each count to go to the jury. Now, in so doing, the court cannot, in this court's view, allow to filter into its decision what the court thinks of any witness's credibility. The court is not making credibility determinations and determining how it will rule on a motion for judgment of acquittal. What the court is required to do and is able to do is to determine what, if any, reasonable and logical inferences can be drawn from the evidence that has been adduced. So the court is going to address the motion in just broad strokes. This is in no way a marshaling of evidence concerning intent of the defendant. The jury can reasonably consider that the defendant's remark that Jennifer Dulos should be buried next to the dog is evidence of motivation. The jury need not conclude that. The jury can consider it. That statement was made before May 24th. The jury can consider certainly that the blood found on the cut garments in the trash on Albany Avenue is evidence of Fotis Dulos' intent to restrain and kill Jennifer Farber Dulos. The jury can reasonably conclude that because the defendant indicated that Dulos was at home on the early morning hours of May 24th, but indicated later on that he was not, that she knew where he was going to go on May 24th and was covering for him. The discarding of evidence on Albany Avenue is an indication that the defendant knew the purpose for which those items were being discarded. The jury can conclude that even though the defendant did not drive Fotis Dulos to Russell Speeders, that there probably was an arrangement whereby he told her, pick me up later at Russell Speeders, which means she knew the reason he was going to be there. The jury can conclude these things. Again, the court is not required to assess the strength of the evidence. The court is just required to determine whether or not there is enough evidence to go to the jury. Now, concerning the remarks about multiple conspiracies, the court believes the Second Circuit has concluded that a conspiracy terminates when the central purposes of that conspiracy are attained. So, for example, if the central purposes of the murder of Jennifer Dulos had been attained on May 24th, that's the end of that conspiracy. Then there's another conspiracy. So, and that conspiracy is to hinder prosecution or tamper with evidence, for example. So the court is not persuaded that the state cannot charge multiple conspiracies. And it is too early to consider at this point any arguments concerning a vacator of any of the convictions, if there are any convictions. So the court finds that there is enough evidence to go to the jury on counts 1 through 6. And the motion for judgment of acquittal is denied. Time is 11:25. We'll resume the session at 11:40. We'll stand in a recess.
All right, this honorable Superior Court now stands in.
Okay, we saw that one coming. Let's go. Okay, here we go.
pick up first is the schedule for the rest of the trial. The court understands that the defense has at least one witness scheduled for today and probably will not conclude until Monday. Is that correct, Attorney Shawano?
We are endeavoring to complete by Friday, but based on just everyone's schedule and whatnot, we may not conclude till Monday morning, but it's very likely we might be able to conclude by Friday. I'm just indicating the witnesses for each day. If they're not as long as anticipated, then we might be done by Friday. We're trying to have everyone here by Friday, but we would have to cancel if it was running late.
Thank you.
And Your Honor, if I may just be heard briefly. Council has informed the state last night of a few names of who may be called today. And prior to them coming out, the state wanted to raise an issue with respect to, I think, 2 of the witnesses outside the jury's presence. So I would ask Your Honor if you wish to do that now or to hold off.
Well, right now, let's just continue with the scheduling.
Yes, Your Honor.
The court is going to assume that the defense will conclude sometime on Monday morning. So what the court will ask both sides to do is file with the court proposed jury instructions by the close of business on Friday. The court will anticipate that the defense will present its last witness on Monday. After the defense's last witness, we will go into the charge conference, which has to be on the record. The court then anticipates after the charge conference, the court will proceed with the contempt hearing. Tuesday morning, closing arguments. Attorney Manning.
Yes, Your Honor. Council informed the state yesterday that they intend to introduce, I'll start with the Farmington police officers, Your Honor, with respect to the evidence concerning the manner of death of Fotis Dulos and essentially the suicide, Your Honor, as well as a suicide note that was found next to him. The state's position, Your Honor, is that this evidence is completely irrelevant to the case. It has nothing to do with Michelle Troconis or the charges that she is faced with, and the state is seeking to be heard on if that evidence is going to be presented, in what way, and some feels that there should be an offer of proof, and requesting an offer of proof with respect to the Farmington police officers that were subpoenaed today. Council also provided the state with the name of a Cheryl Briere. That name appears nowhere in any police report or in connection with this case in any way, shape, or form. So the state is asking for some kind of offer of proof as to what the relevance is of Ms. Briere. I would indicate if it is character evidence, it would not be for truthfulness because the defendant has not testified as of yet. So the only thing the state could assume, and I don't like assuming when it comes to this, is that she would be a character witness or some kind of character trait at issue. I just feel at this point, Your Honor, since Ms. Briere's name is not in any way on any form, report, or in any way connected to the case, the state is requesting either an offer of proof or that she be precluded from testifying.
Do you wish to respond to Attorney Shawano?
Yeah, I don't have my witness list in front of me. I don't want to call it a witness list of names. I just want to refer with that first, if I may. Her name is on the list, Your Honor, so I think that the state's claim is unfounded.
I just want to be clear, I'm not claiming she's not on the list. She was. She's not relevant to anything in this matter. She does not appear on any police report, any statement given, anything that has to do with this case. So the state has no notice as to the content of her testimony. As such, the state is asking for an offer of proof outside the presence of the jury in order to find out exactly what she will be testifying to.
I will just recall what the court said when we objected to witnesses who were irrelevant. The court said they'll take it up as the witness is on the stand if there's a particular question. We filed, I can't even remember how many, 20 motions in limine. The court did not require the state once to do an offer of proof, not once during their case. So the fact that she's now asking for that for a witness just because she did not, or the state did not go out and investigate people that they've had since October. And I know we weren't required to provide a list, but this name was definitely on the list. There were a number of names we put on that list. The state cannot now claim, well, we didn't know when they failed to investigate the names on the list. As the court is well aware, the defense could have simply called people. We don't have to give the court a preview of what each person is going to testify to. They can object if something is asked that is not relevant. I know the rules of evidence. We certainly wouldn't be caught, even if and I note this is not what we're doing, but even if we were going to put on evidence of, excuse me, of character, even if that was, we would not be required to have that person write out a letter of recommendation to what they were going to testify to. So this is not only unnecessary, but it's also unheard of as far as I'm concerned, Your Honor.
Well, the court will first address the representation by the state that a witness is to be called by the defense to testify about the manner of death of Fotis Dulos. How is that relevant?
Well, first of all, this is not this morning's testimony, Your Honor. So again, I didn't get any opportunity to have the defense. The state has not once had to make an offer of proof towards any of their witnesses. The purpose of presenting the evidence of the fact that he is unavailable as a witness, the state was allowed to state on the record that Mr. Mawhinney was unavailable. I'm entitled in our case to show the circumstances under which he is not available in the case. I do not intend these police officers to testify as to cause of death. It's the fact of death. There's going to be a death certificate that I intended to introduce to show he's not available. So it's relevant to the circumstances, certainly more relevant than I would submit half of the state's case was about the lack of evidence that they were able to present.
Well,
So
it is not a stipulation that Fotis Dulos is deceased.
no, Your Honor, and we're not willing to stipulate to that.
Well, the court's question is, for what reason are you calling the Farmington police?
I'm,
State representative is to indicate that Fotis Dulos is deceased. So, and then the court understood you to just say that you're not willing to stipulate to that.
I'm just going to note that at no time did this court require the state to
That's not
give
the question. The question is, you just indicated to the court that you wanted to call the police officer to testify that Fotis Dulos is deceased.
No, Your Honor, I didn't say that. I said that
Perhaps the court misunderstood.
yes, it's the individual officer who found Mr. Dulos in his vehicle on the date in question. That is the purpose and that for the record would be January 28th, 2020. I've heard the state say, well, the jury may have questions about it. There's been some testimony about the circumstances. This is to complete that circle, if you will. And then I would be introducing a death certificate and a decree of death as a certified copy of the decree of probate death, just to close that circle of information. And that is the purpose of that testimony.
The court does not understand what the circle is. The court is under no impression that the jury would have questions about whether or not Fotis Dulos is deceased.
So, again, I made my offer. I didn't think I should have to, but I did. If the court is indicating that we cannot present that portion of our defense, at least it'll be on the record. But I'm indicating that we would intend to put on evidence of where he was found, that he was taken to the hospital. And then there's also the fact, which I would then, once we presented that, there is the suicide note where he exonerates Ms. Troconis. I recognize that it doesn't come in under as a statement in contemplation of death. In other words, not a dying declaration, but I would attempt to present sufficient evidence that it would come in under the residual hearsay exception, that there is no other way to get that statement in. The court may, at that point, in its discretion, determine it doesn't meet that, but I have to put on the evidence in order to reach that point. Again, for the first time in this case, only the defense is being
Counsel, you
required.
need not repeat that. The court was not aware of what defense counsel was attempting to do. It was simply the fact that Fotis Dulos is deceased. The court would not allow that testimony because it's not relevant. The fact that Fotis Dulos essentially wanted to exculpate the defendant is another matter.
If I may be heard on that, Your Honor,
Well, that's going to be a matter that comes up at the time.
that's fine. Thank you.
Again, if the matter was simply Fotis Dulos is deceased, court would not allow it. Which witness is the defense prepared to call at this time?
Robert Haynes, Your Honor.
We can bring the jury in, please. So would you raise your right hand, please?
Judge, the
The jury isn't in yet.
council stipulate, please?
Yes, Your Honor.
Yeah.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Robert Haynes, ROBERTHAINS.
Thank you, sir. You may be seated.
Thank you. Good morning, Mr. Haynes.
Hi.
You go by another name. I know your formal name is Robert Haynes, but can you tell the jury what you're often referred to as?
Yeah, Hutch. Hutch would be great.
And you're here pursuant to the subpoena, correct?
Correct.
You and I haven't spoken until about a day ago.
Nope.
And you're familiar with Michelle Troconis?
Yes.
You haven't spoken to Michelle Troconis since 2019.
No.
Do you own a property with a lake or pond on it?
Yes.
Can you tell the jury a little bit about that property and where it is?
We have a water ski pond in Avon, Connecticut. It's a private membership. We're all very serious water skiers. You would join the club, and it's really kind of a community. It's a very small community. We all pretty much are there most days, and we are tournament skiers, so we practice during the week, and a lot of times some of us will be competing on the weekends and traveling, and there's about 30 members, and it's a big family.
I'm going to ask you a few questions just about the pond and the area. You call it a pond. In terms of compared to other water ski areas, is it a relatively small pond or a large one?
It is small. No, it's very small. A lot of people will ski on open lakes. This pond is about 1,600 feet long and maybe 300 feet wide. So it's not a pond where you can go off and just really ski and go for long runs. It's a competitive site where you're either in a slalom course or you're on a jump, or some people will trick ski. So it's a 3-event competitive lake versus like an open water lake.
Are you
Very
fam-
small.
Are you familiar with the term short setup?
Short setup, yeah. So the short setup is in most places or most lakes, you can get up behind the boat. This is referring to slalom skiing. You get up behind the boat, you have a minute or two to adjust your shorts or whatever, and then you're in the course. You go through gates, you turn around 6 buoys, and then you drop at the end of the lake. Our lake is incredibly short in that you get up and you don't have time to do anything. You are immediately in the gates, you go through the 6 buoys, and then you're in the water again. So you literally come up behind the boat, you ski for 16 seconds, and then you drop down, and then you do it again. So you're not even skiing for a minute.
And this property, that you own this property?
Yes,
Is it private property?
it is.
How long have you had the ski club?
We've been skiing there for about 45 years, I would say. I'm 58. I started skiing there when I was about 10. The club itself is probably, I don't know, 25, maybe a little bit more, 25 years old.
And is the pond open year round?
No,
Can you tell the jury a little bit about how the season works, when it starts and when it ends?
it's very weather dependent, but the earliest we could possibly open would be the end of March if weather cooperated. We have some really serious skiers in our club that will put on heavy wetsuits and ski in very, very cold water. So they might get started at the end of March. Typically we wouldn't really start skiing until May. And we would ski always through September and a lot of times to the end of October.
And during that period of time when you're open during ski season, is it throughout the week? Is it Monday through Sunday or just on the weekends?
It's every day. So it's every single day. There's people there all the time. With 30 members, there's a lot of people in our club that might find odd times to ski when they know there's not a crowd there, because if you go on a Wednesday at 5 o'clock when people get out of work, there might be 10 people waiting to ski, and that could be an hour and a half or 2-hour wait.
Is it more crowded on the weekends?
It's more crowded on the weekends, but on the weekends, everybody has all day. So they can hang out and not, you're losing daylight on a Wednesday. So we may only be able to ski till 8 o'clock at night. So from 5 to 8, everybody's trying to get their ski set in. On a weekend, there may actually be more people there, but you have all day to ski. So nobody's worried about getting their time in.
Would people make reservations to be able to ski, or would they just come down and show up?
Pretty much, they would just come down and show up. So, yeah.
And while people were waiting to be pulled on the skis or to ride the boat, would they often hang out? Is there an area for people to hang out?
So we have a very large dock, and we do have like a picnic area with a tent over it, and we have a couple areas to hang out. But yeah, everybody would socialize in one place or another, and you're waiting. You could be waiting 2 hours to ski, so you're there. You're there just kind of hanging out. You get in and out of the boat. You take turns driving the boat. You take turns riding because you always need a driver and you need somebody riding. So you're working ski lines and, all that kind of thing. So it's busy. Everybody has kind of something to do. But at the same time, these guys, the people that are in the club, most of the people have been members there from the beginning. So it's a family. You're hanging out, talking to them, and, a lot of times talking smack.
And would people bring dinner or lunch down
Sure.
there sometimes?
Yep. So, yep.
And when you say people had been there mostly from the beginning, are you familiar with Fotis Dulos?
Yes.
Was he a member of the ski club?
Yes.
Do you remember when he joined the ski club?
I can't tell you exactly what year, but I'm going to say it was 2005, maybe. I know he moved to Connecticut with his first wife and joined our club. And I got to say it's 20 years ago.
Do you know the name of his first wife?
Hillary.
Had you met Fotis Dulos prior to 2005?
Yes, I've known him. He was a water skier, so I've known him, through water skiing, probably 10 years prior to that.
So since about 1995?
Probably, yeah. So when, the first time I spent any time with Fotis was when I got married. Boy, don't ask me for a date because my wife's out there. I'm gonna get in a lot of trouble. But we flew to Greece on our honeymoon, and I had Fotis's name, and we met Fotis one day, and he showed us around. Our honeymoon was in Greece, and he showed us around Greece. That was really the first time I ever spent any time with him.
And was Fotis a competitive water skier?
Yes.
Were you also a competitive water skier?
Yes.
Did you see him at water ski tournaments,
Yeah, definitely.
in state as well as out of state?
Yes.
Do you know whether Fotis often traveled out of state for competitive water ski tournaments?
He did. He was, in his younger years, he was on the Greek team. So he water skied for Greece. So those are European tournaments. And then he would ski tournaments all around the country in the US.
Did you also come to know Fotis's children?
Yeah,
Do you know whether they water skied?
they did.
Do you know whether they traveled out of the state for competitive water ski tournaments?
They did all the time.
And was that with Fotis?
Yes,
Had you in fact seen them out of the state at competitive water ski tournaments?
yes.
Had you had the opportunity to observe Fotis at the water ski club with his children?
Yes.
Can you tell the jury a little bit about whether or not they water skied together and for the amount of time that they may have stayed at the club, not as to what was said, but just your observations? And to narrow it down to a certain time period, I'll say between 2015 to 2019.
So
I'm going to object, Your Honor. This is irrelevant. It's a vague question. It's
So relevance counsel.
Just as observations and awareness of Fotis during that time and what he observed.
Not relevance exchange.
Did you know Jennifer Dulos?
yes,
Did Jennifer water ski?
no,
Did she hang out at the pond ever?
objection. The time frame vague.
Well, the question is ever. So overruled.
You can answer.
rarely. She would come down. So her kids would be, most of the time, her kids would come to the pond with a nanny, and they would ski with Fotis, and their nanny would be on shore taking care of them. It's not that Jennifer was never there. She was there every once in a while, but she wasn't there most of the time when the kids were there. It was always a nanny.
Prior to 2017, did you ever socialize with Fotis and Jennifer?
Objection.
Round
Relevance 2017, prior to 2017.
relevance counsel.
Your Honor, I'm getting into Mr. Haynes's knowledge of the time period when Ms. Troconis moved into the house and Ms. Dulos moved out of the house. That's going to be my next question.
So the objection is sustained.
Did there come a time in 2017 when Do you know where Fotis Dulos lived in 2017?
Jefferson Crossing, right? Yes.
Is that where
Yes,
Mr. Dulos lived at the time? Did there come a time when Ms. Dulos no longer lived at Jefferson Crossing?
Objection.
Well, what's the grounds, please?
Relevance, it calls for speculation.
Well, if there was a friendship, it would not call for speculation, so overruled.
You can answer the question.
I don't recall him ever, well, he was a builder, so he lived in a lot of homes, but I don't, in that time frame, I don't remember him moving out of that house.
Do you recall whether Jennifer moved out of the house in
Yes.
2017? Did there come a time when you met Michelle Troconis?
I met Michelle very briefly at a water ski tournament in Florida. Fotis had his kids down there. I had my kids down there. And I was briefly introduced to her. I thought it had to have been 2016, maybe,
So prior to 2017,
Yeah,
recall meeting
maybe-
with Ms. Troconis?
maybe 2017, yeah.
Do you know if Michelle Troconis moved up to Connecticut?
Yes, she did.
And do you know when that was?
There was definitely a long gap after after I first met her. I feel like it was probably a year or maybe 2 years after that. Don't hold me to the time frame, but I know she moved up a little bit, a ways after my first encounter with her.
Did around that time period, did Fotis ever talk about an intention that he moved Michelle up here?
Yes, he talked about it, about having a girlfriend, and eventually he was going to get her up here. Yes,
Did Michelle ever join the ski club?
yes.
Do you know when she joined the ski club?
I think it was 2017. I think it was 2000. It was either 2017 or 2018, but she was a member.
Would you see Michelle at the pond frequently in 2017?
Yes,
Would you speak with Michelle when she was at the pond?
yes.
And you said that at the pond, there were sometimes social events?
Yeah, not planned, but there was so many of us around all the time that, regularly, there were summers where we eat dinner down there every night, and there's always other people around. So whether it's simple as getting a pizza or doing something a little bit more where everybody's bringing something, yeah, we had, social gatherings all the time. It wasn't a planned gathering. Everybody would ski and then just hang out.
So between 2017 until early 2019, had Michelle and Fotis attended some of these social gatherings?
Sure,
And had you socialized with Michelle and Fotis outside of the pond on occasion?
yes.
You had told the jury that Fotis had water skied with the children at the pond. Did there ever come a time when Fotis was unable to ski with the children at the pond?
Objection.
Grounds.
Calls for relevance, calls for speculation, hearsay.
Well, court is not clear on the relevance.
Your Honor, I'm going to link it. It's subject to connection. If I can ask a few follow-up questions, I'm going to establish Mr. Dulos's behavior related to the custody and visitation.
Well, there's no foundation for questions about custody and visitation with this witness.
I need to ask some foundational questions, Your Honor, related to
You can
that.
ask the direct question.
Did there come a time when you learned that Fotis could not see his children?
Objection, calls for hearsay.
Well, overruled.
I remember a point where I felt like it was sudden because I wasn't completely knowledgeable on everything that was going on, but I remember that Jennifer at one time left the home, and I believe she took her children with her.
Do you remember, without getting into what was said, Fotis's demeanor or emotion or attitude towards not being able to see his children?
Objection.
Overruled.
Oh, he was upset. He was very upset. Those children were his life.
I'm going to fast forward now to 2019, prior to the ski season getting into full swing. Did Fotis ever express to you an immediate expectation that he would be skiing with the kids at the pond again?
Yes,
And that he was expecting to be able to take the kids to compete in water skiing again?
Object, Your Honor, this all calls for hearsay.
expectation of future, immediate future conduct.
which he would say and express, which is a hearsay statement.
So at this point, the question is, or is the question, did Fotis Dulos talk to this witness about his expectations? Is that the question?
Yes, Your Honor.
And if I may, Your Honor, when, what time, and again, it's a hearsay statement about what he is expressing his statement at a specific time.
I can rephrase that, Your Honor. In early 2019, did Fotis express an intention to be competing with his children again?
Object, is that January? Is that February? Object on time. It's
Well,
vague
the question
question.
is in 2019. So the court is going to overrule the objection.
You can answer that.
He was expecting to get his kids back into skiing and being able to spend more time at the pond and skiing with them again. He did not mention competitions.
Do you recall when in 2019 that was?
That was that Thursday night.
And when you say that Thursday night, was that May 23rd, 2019?
Yes.
Can you tell the jury about his demeanor or attitude towards that expectation?
I mean, it was when Fotis and I talk, 90% of our conversation is water skiing. We never did business together, really. We never had any outside life other than water skiing. He was definitely devastated when he didn't have his kids skiing. So I think he was excited that he was making progress, and he felt like he was making progress. And he definitely said he thought he would have them at the pond a lot more. Prior years, he didn't have them down there at all. And I think he thought he was going to be able to get shared custody and be able to spend weekends with them skiing, and even, sometimes during the week. I think that's what he was hoping for.
Okay, and that was around May 23rd, 2019. I want to talk about May 23rd, 2019, because, well, can you tell the jury if you saw Fotis Dulos on May 23rd, 2019?
I did.
Can you tell the jury a little bit about those circumstances?
Dinner. We were invited to his house for, I wouldn't call it a dinner party, it was 6 of us, just a gathering, nothing formal, and it wasn't last minute. We probably talked about it a couple of days earlier. And we met him, we went over to their house for dinner.
Who were the 6 people who were in attendance at, is this Fort Jefferson?
Yes.
Who were in attendance at Fort Jefferson on May 23rd, 2019?
My wife and I, a local realtor, Stefan, and his wife, Beth, and Michelle and Fotis.
And your wife's name is?
Aaron.
Do you remember what time you got there that night?
Honestly, I don't. I think it was somewhere around 6:30, my guess.
Do you remember what you ate for dinner?
I'm pretty sure it was chicken. It was a Greek salad, maybe French fries. It definitely had a bottle of wine.
Do you remember Fotis stepping out at any point in time in the evening?
I do not.
When you saw Fotis that night on May 23rd, 2019, do you recall whether his hair was short or long?
I think it was short.
And had you ever seen him before in previous years with a very short haircut?
Sure.
And did people at the ski club often have short haircuts?
Yeah, we have a couple members in our ski club who would shave their head, not shave their head, but definitely cut it way back for the summer.
Were you surprised at all about his haircut?
Not really. It was, going from long to short is always a different look, but I wasn't surprised. I didn't think anything of it.
And was anything unusual about that dinner?
No.
Even looking back in hindsight, was there anything unusual about that
No.
dinner? You talked a little bit about Fotis's mood. Did he seem happy?
Yeah, it was just, happy. He was very friendly. We hung out. It was very relaxed. There was nothing odd about it whatsoever.
Even now, looking back, all those
Even now, looking back,
in hindsight.
yes.
Do you recall what time you left that evening?
I'm guessing it was somewhere close to 10 o'clock.
Do you know whether you left before or after, you said Stefan and Beth?
I feel like I left before, They did. And the reason I think that is because I remember walking out and seeing a nice car in the driveway and saying, real estate must be good.
Is Stefan in real estate?
Yes.
Do you recall leaving of your own accord, or was anybody wrapping up the dinner?
No, I think, no.
After you left, so that's May 23rd, 2019. Did Erin leave her purse at the house?
Yes.
Can you tell the jury a little bit about the circumstances surrounding how you found that out and what happened next?
We drove home, and I think when we got home, Erin realized that she had forgotten her purse, and instead of, she wasn't overly worried about it. Instead of, it wasn't like at a restaurant, it was in somebody's house. And I don't remember whether she, I feel like she may have texted Michelle that night and said, I forgot the purse. It might have been the next morning. She may have been the next morning. I don't remember.
And how did the purse was the purse eventually returned to your wife?
They had texted between themselves and arranged to have Michelle drop it off in my office, which she came by and handed me the purse.
Do you know, when you say she came by the office, is that at the pond?
Yeah, it's in front of the pond. I owned a business there, a self-storage facility with an office up front. So it was my place of work. So I was working and she just walked in and handed the purse.
All right. Do you know if she handed the purse directly to you? Or
She
to-
did.
Okay. Do you recall talking to her at all when she came?
It was very brief. I feel like she was going to the grocery store, mentioned on my way to the grocery store, but it was a 10-second conversation, not even.
Was
And
there anything unusual about her demeanor at the time?
No.
Even looking back in hindsight?
No.
So that weekend, that was Memorial Day weekend, at some point, you learned that Jennifer was missing.
Mhm.
And at any point in time that weekend, did Michelle or Fotis come to the ski club?
We did not see them Saturday, but I saw Michelle at the pond pretty much all day on that Sunday. I believe Fotis was going to see his kids or try to see his kids Sunday, so he was not there. Michelle spent the day at the pond with her daughter, and then Fotis, I think later, it was probably late afternoon, early evening, showed up at the pond.
And can you tell the jury a little bit about what Michelle's demeanor was like on that Sunday at the pond?
So I believe there was state police at her house. I don't know whether they were in the house or parked out in front, but I know she didn't want to be there. So she was obviously agitated. I remember she tried to skate. I mean, the water was still very cold, but she was upset and she was definitely teary-eyed.
And you said Fotis came later in the evening?
Yep, Fotis, I don't think he was able to see his kids, so I think he ended up back at our place or back at the pond. I'd say sometime, it was later, maybe 5:30, 6 o'clock.
Did Fotis, when he came, seem upset or concerned?
He was upset that he didn't see his kids for sure. Yeah, he was upset.
But that was your impression that that's what he was upset
I feel
about?
like he was upset that he didn't, yeah, he wasn't able to see his kids.
During that weekend and the days that followed, was there a lot of media presence at the pond?
Yes, it was unbelievable.
Was there heavy police presence at the pond?
There was heavy everything at the pond. So we had, I mean, it was nonstop. So you have podcasters calling, you have reporters driving in, calling, the state police, showing up at my office to look at surveillance. Our pond it's sacred ground to us. We have 30 people in our club that love that place. And the state police come in with dogs and they search the place with dogs. And then they put a boat in the water and they go over the whole pond with a boat looking for a body. It was awful.
And it obviously still is upsetting for you.
Yeah, no, it was probably one of the most painful times of my life.
And they searched your property pretty thoroughly.
Yep, I gave, the state police came down early in the week and I gave a tour and showed somebody and told them all about the pond. And then I feel like it was a couple days later, they got a search warrant and they came down with dogs and taped off the whole place. And there had to have been 20 police officers just doing their searching the whole place. And then I don't know if it was a couple weeks later or it was when it was, but they came and did it again, this time with a boat, to put a boat in the water.
And you cooperated fully with that.
Absolutely.
Did you speak to Fotis around that time?
The only real contact, I mean, around, so, yeah, I mean, during that week, no, I didn't see him at all.
In May of 2019, do you remember Fotis ever saying something to you about Jennifer having left in the past and he expected that she would show up?
Objection.
Effect on the hearer listener, Your Honor.
Well,
then
the
it's
court-
irrelevant.
no, This is not going to be a street corner argument. The court knows of no exception to the hearsay rule effect on the hearer. In this court's view, that's folklore. That's not the law. Then existing emotional or mental condition is an exception to the hearsay rule. This is not being offered, as the court understands it, for the truth of the matter is overruled.
You can answer that question.
So Fotis would look at me and over, the few times I saw him, he would say, I did not do this. I did not do this. And he did at one time tell me that Jennifer had run away at some point earlier in her life, and I don't know the details of it. And he said she's doing it again.
Have one moment, please, Your Honor. I have no further questions. Thank you.
Cross-examination, please.
Thank you. Good afternoon, sir. How are you?
Good.
My name is Michelle Manning. I represent the state. I'm gonna ask you a couple questions, okay?
Mhm.
Now, briefly, you talked a lot about on direct about you own the pond,
Yes,
okay? And that's what the ski club. What is the ski club called?
Old Farm Skiers.
And it's members only?
Yes,
And Fotis Dulos was part of that water ski membership?
yes,
Okay, and Michelle Troconis was as well?
yes,
Now, you also own the storage facility that's around that pond?
yes.
Okay.
Did,
And with respect to, water skiing is important to you, correct?
yes,
Yeah, you've been doing it a very, very long time,
Yes.
correct? Okay. So, I mean, you own a pond, I think you described everybody as a community, would you
yes,
say? Okay. And Michelle Troconis was part of that community, wasn't she?
yes,
And in fact, you talk about many times that you would just hang out on the dock, maybe have dinner together, things like that, is that correct?
yes.
And you would talk to her a lot during the time she was there, correct? You socialize
We'd socialize, but in a group.
in a group,
Yeah,
Yeah.
and like,
in English?
yes,
And I want to ask you some specific questions about the party on May 23rd. It was planned a couple days in advance. That was your testimony,
I
correct?
think so, yes.
Okay. And you've had, you didn't know that Stefan Reich and Beth Johnson were going to be there that day in advance, did you?
I feel like I did.
You feel like you did?
Yeah, I think there was going to be 6 of us, yes.
Okay. Was Stefan Reich part of the Water Ski Club?
No,
Okay, and Beth Johnson wasn't either.
no. That was, honestly, that was the first time we met them.
That was the first meeting that night. Okay. And you were invited by Fotis Dulos?
Yes,
Okay. And you got there, I think you testified around 6:30?
I'm guessing, I don't know. I just don't remember exactly what time.
It's been about 5 years, you would say? Is that fair to
Yep,
say?
Yes,
Okay. And when this first happened, there's a lot of media attention?
Yes.
I think you talked a little bit about it. You mentioned this was a very difficult, I think your words were, this was the hardest thing that you've ever gone through in your
Mhm.
life,
yes,
was the media attention?
Mhm.
Okay. By the way, you see the camera behind me?
yes.
And it's been, have you been watching on TV?
No, haven't seen a single second of it.
Okay, but have you noticed the news reports?
No, I won't watch it.
You won't watch it at all,
Mm.
right? Because you're very close to Fotis.
Yep.
Okay, it's
Well-
very, very big part of your life. I think you said 30 years.
Yes,
Now, at the dinner party that night, kind of impromptu dinner party, you'd say, right? It wasn't very formal.
no,
Okay, it was you, your wife?
yes,
Okay, and Stefan Reich, correct?
yes,
Beth, I think she was Johnson at the time. Yeah. And Michelle Troconis and Fotis Dulos, correct?
Right.
Okay. And I think you testified that there was nothing odd about it. Those were your words, correct?
that's correct.
Okay, but Fotis talked about the fact that he really couldn't wait to get that. He had an expectation he was going to get the kids again, right? Is that correct?
Yes,
And he talked about, I think you testified, you talked about the fact that on May 23rd, he was excited. He was going to take the kids water skiing again. I think that's what you said too, right?
Yes, he said he was making progress where never before has he been making progress to get them, to get
Never-
custody, or to get visitation.
Never before? You remember him saying that?
Repeat that?
You said he's been making progress where never before he's.
Well,
been-
up to that point, I don't think he really had the kids at all. And not even, I mean, he would be able to see them once in a while, but it wasn't very consistent.
And on May 23rd,
He
said-
mentioned that he thought he would be able to get more visitation and that we might be seeing the kids at the pond where we haven't in a long time.
Did you discuss the plans to murder Jennifer the next morning at the dinner party?
Say that again?
Did you discuss the plans did Fotis Dulos discuss and Michelle Troconis discuss the plans to murder Jennifer at the dinner party on the 23rd?
No.
Did they discuss with you at the dinner party to dispose of evidence of the murder in the garbage cans of Albany Avenue?
Objection.
Brown.
Argumentative.
Well, the question is essentially a leading question that was the intent to murder Jennifer Dulos discussed at the dinner party? And your objection is argumentative. Well, the clear answer from this witness is going to be no. So the objection is overruled.
Did you have those discussions, sir?
No.
And what about the plan to use the Tacoma and clean it afterwards? Did he discuss
To-
that?
To what?
To use a Toyota Tacoma and then clean it afterwards? Did he discuss that with you?
No.
And you talked a lot about the media influence on the pond and how the police coming with, I think, did you say they searched the pond one day and then they came back with a boat and
Mhm.
divers? Did they do that? Okay. And that was the worst experience of your life, them searching?
It was an awful experience. It was an awful experience.
Yes, awful experience searching.
The whole thing's an awful experience.
Of
Yes.
course. You watching the pond being searched for a dead body of a mother of 5 was awful for you. We understand
Objection, Your
that.
Honor.
Sustained.
And nothing further, Your Honor.
I have a few follow-up questions. The state had asked you about speaking to Michelle Troconis, and she spoke English, correct?
That's correct.
Did she sometimes struggle to find the right words?
Sometimes.
And she would ask what certain things meant?
Yes.
And the state had asked you about Fotis's communications about making progress. Were you aware at the time that custody report had come out?
Objection.
Sustained.
Did Fotis talk specifically about court proceedings in terms of making progress?
Objection.
Well, did he talk about it? The answer is either yes or no. The witness does not remember, so that's overruled.
Do you want me to re-ask that?
Yeah.
When you had mentioned that Fotis Dulos was talking about making progress, was that in the context of the custody proceedings in court?
Yes.
And the state asked you some questions if you were part of some plan to do something nefarious, and you had said no.
No.
You've known Fotis for decades,
Yes.
right? And even in hindsight, looking back, there was nothing to alert you to the fact at the time, right?
No.
Nothing at all?
No.
No further questions.
Nothing further. Thank you.
Mr. Haynes, you may step down. Is there another defense witness available at this time?
Yes, we won't get done with that witness, but we can certainly start unless the court wishes. I figure we should start. Yeah. And I've had Attorney Felsen is, I think, bringing him in at this point. Just want to switch back.
Do you solemnly swear or solemnly sincerely affirm this case may be, that the evidence which shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Can you please state your name and spell it for the record?
Stefan Reich, STEPHEN REICH.
You may be seated. Thank you.
Thank you.
Good afternoon, Mr. Wright.
Good afternoon.
Would you please indicate to the members of the jury what you do for a living?
I'm a real estate agent with Coldwell Banker in Avon, Connecticut.
Where do you live?
Avon, Connecticut.
With whom?
My fiance Beth Reich.
How long have you been a real estate agent?
Since 2009.
Can you tell the jury a little bit about what kind of real estate, there's different kinds of real estate agents, right?
Yeah, you have commercial, residential. Yep. So I worked primarily residential, new construction, land acquisition for building, luxury properties, and that's most of what it was.
What area, is it mostly in Connecticut?
Yes, mostly the Farmington Valley of Connecticut. So Avon, Farmington, Simsbury, West Hartford,
Can you tell me whether or not you knew Fotis Dulos?
I did, yes.
Did you know Michelle Troconis?
I did, yes.
How did you get to know Fotis Dulos?
Actually met Jennifer while she was walking the first set of twins, Petros and Theodore, at the development they lived in Canton and Griswold Farms. I lived there as well. I met Jennifer while walking the dog a few times and seeing her around the neighborhood.
And for the record, when you say Jennifer, who are we talking about? What's the full name?
Jennifer Dulos, Jennifer Farber Dulos.
And at the time you met Jennifer Dulos, was she married to Fotis Dulos?
Yes, she was.
Did you become, could you just tell us whether or not you had a friendly or unfriendly relationship with the Duloses back then when you met Jennifer?
No, very, very friendly.
Can you just describe briefly, you said you met Jennifer when she was walking her twins in a stroller?
In a stroller,
Could
correct.
you just describe in a little bit, did you have a conversation, just see her, what did you do?
I saw her, we just, started a conversation, they were new to the neighborhood, I was new to the neighborhood, I moved from New York, we just, kind of hit it off, just having general conversation. I had seen her subsequently a few times while she was, she would walk the babies in the strollers quite often. And she had suggested that we come over to their house with my ex-wife at the time to just have a drink and get to know each other.
And did you do that?
Yes, we did.
Approximately what year was that, if you recall?
I would say probably 2008,
How far away did you live from the Duloses back then?
less than a half a mile.
Was it the same neighborhood or
It was-
just on
it
the
was-
same road?
The same subdivision, same neighborhood. We were on one street, they were on the next street over, down the road.
Did you also develop a social relationship with Fotis Dulos other than just going there once for drink?
Yes.
How would you describe the relationship as it developed over the next few years?
The relationship between whom?
Between maybe I should separate them, between you and Jennifer Dulos and you and Fotis Dulos during that time?
We had gone out to dinner several times. I mean, we just, would mostly go out to dinner and socialize. And, we'd always talk. And I was transitioning work-wise from a family business, and Fotis had suggested that, I possibly get my real estate license and do sales and marketing for his company.
Did you go into real estate and get your license because of Fotis Dulos' suggestion?
I did, yes.
Could you tell us what was the employment of Mr. Dulos at that time when he made that suggestion?
What did Fotis do for a living? Is that
Yes.
the question?
Yeah.
He owned a company called Coverup, which was, a higher end luxury home builder in the Farmington Valley.
When you got your real estate license, did you have any professional dealings with the Ford Group?
Once I got the license, I obtained all of the listings that the Ford Group had.
And would that indicate that you had income from and through the Ford Group?
Correct. Not
During that
exclusive-
time frame, did you continue to maintain a social relationship with both Jennifer Dulos and Fotis Dulos?
Yes.
Do you water ski?
I am not a water skier. I snow ski, but I have water skied with them. I think maybe 3 times, but that's just not really my thing.
So when you say with them, did Jennifer Dulos during that time frame water ski?
I water skied at the pond, I believe, 2 times with Fotis at the pond in Avon. And then I did water ski with Fotis and Jennifer in Greece when we were there for Clay and Noel's baptism.
So do you know what year that baptism would have been of Noel? She was the youngest daughter,
She
correct?
was
Do
the youngest one, yes.
you remember approximately what year that
I
was?
don't remember the exact year.
What were the circumstances of you being in Greece at the same time as the Duloses back then?
They invited us to go there for the baby's christening and to have a vacation.
Where were you water skiing with the two of them?
I don't know. It was an area where Fotis had skied kind of growing up, and we skied with some friends of his, and Jennifer was on the boat and she skied as well.
Do you recall whether or not Fotis Dulos was involved in any competitive water skiing activities during that time where he'd actually compete?
He was, yes.
Did you ever observe or go to I don't know if it's called a tournament or a meet?
I don't believe I've been to a competition. I mean, I have seen him ski at the pond, a couple times, but I don't know if that was a competition per se.
Did you ever observe any medals or ribbons or any other certificates he got as in his competitions?
Yes, I've seen that.
Where did you see them?
Probably Facebook post or, after an event, he would tell us how he did.
You have how many children?
I have one child, one biological child.
Was your child of similar age to any of the Dulos children?
My child was the same age as the second set of twins.
And for the record, how old is your child now?
15.
Did your child go to school with any of the Dulos children?
Yes,
Where was that?
the Farmington Valley Academy, Montessori, and Avon.
Did there come a point when the Duloses moved from your neighborhood to another?
Yes.
Do you recall when that was?
I don't remember the exact date now.
Were you at the time working for a real estate company or were you on your own?
No, working for a real estate company. I started with William Ravis from when I got my license, I think 2009 to 2017, and then I've been with Coldwell Banker since.
Did there come a separate time when you went to work for the Ford Group as an employee?
That is correct. I still maintained my real estate license, but I was not a 1099 with Forbes. At one point, I was a salaried employee.
When you say 1099, if you're a real estate agent, how do you earn money if you're selling property through that's being built by a builder?
You're earning commissions, and then you're getting a 1099 from the broker at the end of the year.
Tell the jury about your employment at Ford Group, where you actually were you were salaried.
Correct.
Could you just tell the jury how that came about?
Fotis did not like the fact that I was earning a lot of money in commission on the sale of some of the property. So
Was there a significant drop off that permitted these views?
yes.
Could you just describe that rather for the jury?
Well, you had the house and then you had a backyard and then it dropped off significantly.
A cliff?
I wouldn't say a cliff, but yeah, pretty steep.
Was it at the top of Avon Mountain?
It was, yes.
You said that you had 80 Mountain Spring as you were under contract or you were the realtor for that property as well?
Correct.
You said you lost it for a period of time?
After I was terminated, I believe he gave it to somebody else, and then I believe I did reacquire the listing, and then subsequently sold it.
Were you the listing agent in 2019 for 80 Mountain Spring?
Yes,
Were you familiar with the work that was being done to convert 80 Mountain Spring into a property to be sold?
absolutely, yes.
Could you indicate to the jury a little bit about the property? They've seen photographs, they've seen aerial and drone footage, but could you describe what this house was and how it was converted?
Well, I did sell the property to the Ford Group from the original owners of that. Well, I don't know if they were the original owners, but I represented Ford Group to purchase the property. The house was very dated, needed a lot of updating. Some of the rooms were very choppy. On the third floor, there were like 5 or 6 bedrooms, a living room, kind of very small. I mean, the house it's a 100-year-old house. So we purchased the home. Ford Group purchased the home, hired a well-known architect from Fairfield County, and did just a complete remodel of the house. I mean, top to bottom, everything was redone.
Was the house demolished or was it reconstructed and expanded? Could you explain?
Reconstructed and expanded. The original house had a 2-car garage that was actually below grade, so you would park underneath the house and have to go upstairs to get to the main level. What Ford Group did was they added a 4-car garage on the east side of the house and had a very large bonus room above that. So they added a 4-car, they got rid of the basement garages, added a 4-car garage plus the bonus room above that 4-car garage as an addition to the original home.
How much acreage did that property have?
I don't know exactly, but around 7.5 to 8 acres in total.
Do you know whether or not that house in May of 2019 was completed? That is, was construction completed?
It was, yes.
Was it being marketed at that time?
It was, yes.
Had there been showings of that house?
Yes, there was.
Incidentally, if there was a showing for the purchase of the house, were you present usually?
If the listing came through the MLS, if there was another agent that wanted their client to see the house, I would be notified because I would have to approve of the showing per se. And Fotis did insist that the listing agent be present at all showings. It makes it a lot easier to talk about the highlights of the house, and there was so much work that was done. He felt, and I felt as well, it would be vital to have me there to kind of explain the work that was done, all the attributes of the house, and answer any questions. So on showings that were originated per se through the MLS, I would be present.
Were there times when a real estate agent might show that property to someone that you were not present?
The only circumstance that would be is if Fotis was showing that house as a representative sample of what a custom home could be. So if there was a client that was interested in building a custom home, they could, sometimes Fotis would show him that house to say, you know, clearly for this case, not the outside, but on the inside, this is, you know, the quality of our work.
In other words, they would not be seeking to sell that house, that property through a different agent. They would show it as a representative of his work. Is that what I understand?
Correct. And they've done that with Ford Jefferson, and they've done that, you know, could be any of the properties.
In fact, was Ford Jefferson Crossing for sale technically at the time that Fotis was living there in May of 2019?
I'm not 100% sure.
If there was a for sale sign out front, would that suggest that?
Yes,
Shown in
Yeah.
videos?
it had been on and off the market, yeah.
When you worked for the Ford Group, how often would Fotis be in the office when you were there?
Most times, unless he was traveling, he was usually there.
Did he work long hours that you observed?
Sometimes,
When you came in, what time did you usually come in when you worked?
8:30, 9 o'clock.
And when you came in, did you often see him there already at work?
Yes,
And after you left in the evening, what time did you usually leave?
4:30 to 6 o'clock, depending on what we were doing.
And when you were working there, was Fotis still often working after you left to go home?
Sometimes, yes.
You said he traveled. Would you just tell us a little bit about how often he traveled while you were working there?
Towards the end, when I was working there, travel definitely increased. Miami, go skiing, competing. I know he went like internationally to competitions, but it seemed at the end he traveled more.
While you were still working there, did you ever have conversations with him about whether his children would be competing?
He did mention, yeah, I believe some of the children did compete. I think Petros and Theodore did.
Water skiing?
Yes.
Was that nationally or internationally, if you know?
I don't know. I think maybe both, but I'm not 100% sure.
Did you know the Dulos children?
Yes.
Was the office part of the house, or did it have kind of a separate space and entrance?
It was a part of the house. I mean, they designed that house to have a home office. There was kind of an employee subcontractor entrance on the right side of the porte cochere, which is the breezeway, which goes from the front to the back of the house to that parking area. So we would always enter the house through that door on the right side, up the stairs and into the office. But then you could get to the main house from, I think, the east side of the office went to one kind of sitting area on the second floor. You go down the hallway to the bedrooms, or there was a staircase down which went to the mudroom and towards the kitchen.
When you were working there, did the employees tend to wander into the residential portion of the house?
No.
It was basically separate?
Well, I mean, you could physically walk there. We just, you know, we didn't.
I want to ask you specifically now about whether or not you continue to socialize with Fotis after you became the realtor and were no longer working for him.
I did, yes.
What kind of socialization or social activities did you engage in with him at that point? That is,
Go out.
after you left?
Go out to dinner or go to the house once in a while.
And at the time, did you have a partner?
Yes, Beth.
Okay, could you just indicate, Beth, what's her whole name?
Beth Johnson Reich.
Are you now married to her?
No,
Would you socialize together with Beth and with Fotis?
Sometimes with both of us, sometimes independently.
Do you recall a time sometime in 2017 when Michelle Troconis had moved into the house?
Yes,
Did you ever see her when you were at the office for real estate related matters?
I believe so.
Did you talk with her?
I'm sure I did. Yeah,
Did you socialize with her and Fotis?
I did.
Did you socialize with her separately, that is you and Beth with Michelle without Fotis?
No,
How would you describe your relationship with Michelle Troconis after she had become part of the household?
I mean, I think I've only met her 6, 7, 8 times, but it was always positive, friendly. I mean,
Was there a time in 2019 where Mr. Dulos would talk to you about the status of his custody battle or custody dispute with Jennifer?
Objection. Calls for hearsay.
Well, it calls for a yes or no answer, or perhaps the witness does not remember, but at this point, it does not call for hearsay. So overruled.
he did, yes.
Could you just describe what in general he would say about the process to you? And it's not being offered for the truth, it's the fact that it was said.
Well,
Objection.
the court understands the phrase, it's not being offered for the truth, but if the court cannot see other than being offered for the truth, the court is going to sustain the objection. What did he say about the custody battle? If it's not offered for the truth, what is it offered for?
It's being offered to show how Mr. Dulos was projecting his optimism towards the situation, and that's the purpose, not to the actual truth.
Well, then the question is, first question that was asked, did he discuss with you the custody matters that concerned him? The answer was yes. The next question, based on what counsel said, need not deal with content. It's his response to whatever custody issues were occurring at the time. For example, this is just the court's view to avoid a hearsay objection. Was he aggravated? Was he happy? Was he enthusiastic? Was he expectant?
All right, let me ask a question that would encompass what the judge's concerns are.
Okay.
Did you, the preliminary question is, did you have such conversations with him about it?
Yes.
That would be in around April and May of 2019.
Even before, but
in that time frame, could you, using as opposed to his words, could you describe his demeanor, attitude, his outlook about it?
can you put a time frame
Yeah.
on that? Because
End of
I've
April
seen
into
different
May.
emotions,
Yes,
you know,
April into May of 2019, that time frame.
positive emotion.
Did there come a time, did you become aware, at least, that there had been a report that had been issued, without going into what it is, that there had been a report on the custody matter that he had seen?
Objection, Your Honor.
Sustained.
Did there come a time when you were invited to dinner in May of 2019?
Yes.
Could you tell the jury a little bit about how that came about?
We were actually supposed to have dinner with them on the Tuesday prior to Thursday.
So that we're clear, are we talking about the week that, did you become aware at some point that Jennifer Dulos had been reported missing?
Yes,
Would this have been in that week just prior to that?
when we had dinner,
When you had the discussions about it?
that would have been the week before we actually had that dinner on that Thursday night.
Okay.
Yeah.
So how did it come about? You were just beginning to say you were supposed to have it on a different.
We were
night.
supposed to have dinner on Tuesday, and then I mixed up the custody schedule with the kids. So that week, we have alternating schedule with the kids. So one week we'll have them Monday, Tuesday, one week we won't have Monday, Tuesday. So we had the kids Monday, Tuesday. We were supposed to have dinner on Tuesday. I let them know that I mixed it up. I can't do it. We don't have the kids Wednesday, Thursday, but Beth coaches her kids' soccer team, so would Thursday work? So he said, yeah, come over Thursday, 5 o'clock. We'll come to his house. We were going to look at some rugs from Michelle, and then the plan was to go to a Japanese restaurant in Avon.
Now, there was, just to clarify, when you talk about visitation and custody, we're talking about your children, not Mr. Dulos.
Yes, correct. Yeah,
Okay. So the plan was set to get together at what time?
5 o'clock.
And were there email exchanges with regard to that?
There was text message exchanges. Yeah,
Can you tell me whether or not, well, who did you go with, first of all?
with Beth.
Do you know approximately what time you arrived?
I don't know exactly, but if we were supposed to be there at 5, I probably would have got there at 5 or a couple minutes before.
When you first arrived, where did you first see Fotis Dulos when you arrived?
I was heading north on Eli towards Jefferson Crossing. And prior to us entering Jefferson Crossing and making a right into Jefferson Crossing, Fotis was leaving. So I passed him on Eli Road prior to entering Jefferson Crossing.
Prior to passing him, did you stop and have some conversation near the intersection?
Yes.
Could you just tell the jury what that was about?
Objection.
Well, what the conversation was about is just what was the topic. The court will allow that overruled.
He just said, oh, I'll be right back. Go head on over and I'll see you in a little bit.
Did you say anything to him about him leaving at that moment?
But yeah, I mean, he was like notoriously late. We used to call it Fotis time, so I was like, oh, classic Fotis, I'm coming and he's leaving. And he said he'll be back shortly and, head on in.
When you said that if the time was 5, you would have been there at that time or earlier, did you have a habit with regard to punctuality?
Yeah, I like to be punctual.
Was there any reason that you would have been delayed or not be punctual that day?
It's possible, but not likely.
So when he left, did you continue on to the house?
Yes,
And did you go to Fort Jefferson?
yes, we did.
You pulled into the driveway?
Mhm.
Did you pull into the back?
Into the back, yes.
So just tell us what you did when you went in.
Went in and I think we greeted Michelle.
This is our latest hearing aid, packed with 20th century technology. Why beige? To blend in.
Yes, we did.
You pulled into the driveway?
Mhm.
Did you pull into the back?
Into the back, yes.
So just tell us what you did when you went in.
Went in and I think we greeted Michelle and I don't remember exactly play by play, but we did. But she was selling these like really cool rugs from South America, like kind of cowhide rugs. So we went early to purposely just go and look at the rugs to potentially purchase. And then the plan was to go to dinner.
And we being who exactly?
Beth and I.
You said the plan was to go out to dinner originally, is that right?
That's correct.
Did you end up going out to dinner?
No, we did not.
Would you tell the jury what actually happened in terms of, did you eat? Let's start with that. Did you get to eat?
Yes, we ate
All
dinner
right,
there.
would you
Yes.
explain the circumstances, how that,
What came about?
how you ended up eating? Where did you eat?
We ate outside on the patio.
What did you have?
We had steak, French fries, and a salad.
Now, Mr. Dulos told you in the intersection on Eli Road that he'd be right back. Did he come right back?
I believe he came back shortly thereafter, yes?
Did he stay or did he go out again?
No, he did go out again.
What was the circumstances where he went out again?
He said he needed to get more meat to, facilitate cooking for everybody.
Did you see him leave?
I maybe saw him left the house. I didn't see him depart, but yeah.
Did he come back at some point?
Yes,
Do you know how long approximately he was out?
I don't know. Half an hour, something like that. I don't know.
Incidentally, are you familiar with what's called the Little Stop and Shop in West Hartford?
Yes, I am.
In relation to where Fort Jefferson Crossing is, can you tell us whether that would be the closest grocery store?
I'm trying to think of the closest.
Before you, let me ask a different question first. There's now a Whole Foods in Avon, is that right?
That's correct.
Was it finished and operating in 2019?
No, it was not.
Okay, so if that didn't exist, would the Little Stop and Shop in West Hartford be the closest?
Distance-wise, it might in fact be.
Okay. You don't know which store he went to?
I do not know.
Do you recall whether he came back with some meat to grow?
But he said he was going to get meat. I mean, we all ate meat, so I assumed he came back with meat.
So when he came back, what did you do?
We were outside, probably cooking on the grill, having a drink, talking.
How would you describe the atmosphere during that dinner?
Positive.
When you say positive, what do you mean?
It was a normal dinner party. I mean, we were talking, laughing, talking about real estate, joking around. I mean, it was just like, it was a normal evening.
Did Mr. Dulos at all talk, well, what did he talk about?
Objection, hearsay, and
Well,
Your Honor, it's not being offered for the truth. It's,
well, if the question is what topics came up, we're
Right.
going to allow that.
What topics? We talked about real estate. We talked about politics. I mean, just a bunch of different topics. I don't remember exactly what was said and like throughout the evening, but it was just a normal evening.
did he talk about his children?
Yeah, yeah. He loves his children. He misses his children.
What was his air or his attitude about things with his children?
He was of the belief that things were getting better as far as the potential custody of his children.
And did he seem happy or sad?
No, that night he seemed happy.
Were people at this, and did anyone else come to dinner that night?
Yes.
Who else came?
Hutch Haynes and his wife, Erin.
And again, was the atmosphere similar when they were there?
Yes,
Were people laughing?
yes,
Were they eating?
yes,
Was Fotis known to be a good cook?
yes.
Did he do the cooking?
He did the cooking.
Did he make a salad?
He made the salad dressing. I don't know if he made the salad, but
You said French fries. Was there anything particular about Fotis Dulos' French fries?
I'm gonna object at this point, Your Honor.
Sustained,
Do you have a special machine to make French fries?
Objection,
sustained.
How long were you there that evening at the house?
probably till around 10:15.
And after were you the last couple to leave, or did the Haynes leave
No,
first?
the Haynes left first, and then we helped clear all the stuff from the table. I think Beth and Michelle did the dishes, and I think we left shortly after that.
And did you continue to talk with Fotis while you were cleaning up?
I would imagine so, yeah.
Did either he or Michelle disappear for a period of time during this dinner party?
No.
Was the atmosphere the same even at the end, after dinner, after you were cleaning up?
Yes.
Was there anything at all at the time that you could think of that suggested that things were not going well that evening?
In respect to what? Like,
That
just-
in his attitude or anything, did he ever act in any kind of surreptitious way or disappear, get on his phone or anything like that?
No. I mean, he might have got on his phone. That's certainly possible, but there was nothing that jumped about at me, even with the benefit of hindsight, that something was wrong.
You actually were interviewed by the police at some later point, correct?
I was, yes.
you were asked whether even in hindsight, whether there was anything that seemed off that night, correct?
Correct.
And as you sit here even today, was there anything that you think of that raised any kind of red flag with you that something was off or odd?
That evening, no.
I'm going to ask you if you know the name of Rania Minutis.
I do know the name, yes.
Who is she?
She's a real estate agent in the Farmington Valley.
Just have a moment. I forgot to ask you, when you first arrived at the house with Beth, did you see any of Fotis's employees on the property at that time?
On the property, no.
Did you see any before dinner?
Yes, as I said earlier, while we were pulling in before we made a right into Jefferson Crossing, Fotis was leaving and one of the employees was behind him.
Do you know who Pavel Gumieni is?
I do, yes.
Did you see him at all that evening?
I don't remember, and when I was interviewed, I didn't remember who was behind him. It was either Pavel or Andy, and I couldn't definitively say it was Pavel or it was Andy. It's not something I commit to memory. I just saw them leaving and pulled in.
Were they in separate, when you say behind him, in the same vehicle? Or in
No, different vehicle.
I have no further questions.
Good afternoon, sir. How are you?
I'm good, thank you.
I just want to start by actually asking you a couple questions about Jennifer.
Okay.
You talked on direct about meeting her first. I think you lived at the same complex. Is that correct?
That's correct. In Griswold Farms in Canton.
In Canton?
Yeah.
Okay. You actually said on your testimony you remember her walking Petros and Theodore, right? In the stroller?
In the stroller, yeah.
Okay. And did you actually become friends with her first before Fotis?
I did meet her before Fotis, yes, and I probably saw her 3 times while she would come up my street on the cul-de-sac. And I saw her once getting the mail, and I saw her a couple times while I was walking the dog. And we chatted the first time, new to the area, she was very friendly, said, "Hi, I'm Jennifer, and these are my 2 boys." We lived down the street, and
that started your.
that kind of started it, yeah.
Okay. And you also talked about going to Greece for even the 5th child, the youngest,
Correct.
Noelle, for her christening.
Yeah.
Okay. So you've been a part of the kids for a while when they were young.
I knew all the kids, yes.
Okay. Would you ever think Jennifer Dulos would have left her children?
No way.
You also talk about Hillary, or Hillard, actually, I should
Hilliard.
say, Hillard. Yes, and you were grateful to Hillard, I think you said in your testimony, right?
Yeah,
Explain-
I think he was very instrumental in the success of Farber.
And Hillard is Jennifer's father.
Jennifer's father, correct.
Okay, can you just explain why you think he was successful in the success of Farber?
Because he helped finance a lot of the company. So if there was, in real estate, timing's everything, right?
Mhm.
So there was a builder that had bad times. They had a bunch of lots, and we could buy them from the bank or at a distressed price, but you needed the capital. Like Hilliard gave the company, not us, gave Fotis and Farber the money to buy really whatever was needed. And, we would run it by him. He would, look at the numbers, make sure it was a good investment. But if he felt it was warranted, he helped Farber out with that on multiple occasions.
And this was over the years, correct?
Over the years, correct.
Okay, so if ever there was something that Farber was lacking cash in or wanted a big property, Jennifer's father would help out.
Yes,
Okay, and when he passed, you reached out to Jennifer.
I did, yeah.
Now, I have a couple other questions just about Farber. When you were working and correct me if I'm wrong. So you were working for Group, then you wouldn't sign the non-compete. So you were fired, but you still had a relationship with Fotis.
He gave the listings to other agents with the exception of, I believe, one, which was 585. It was either 585 or 80. I'm pretty sure it was 585. So, he kept me on and gave me something while he started, giving out listings to other agents at the time. So
Because you wouldn't sign the non-compete.
I think it was, yes.
And eventually you came back to work for Group, is that right?
I never came back to work with them. He would then give me more listings. He'd give me some of the listings back.
Now, at some point, and you would get, and I'm probably not saying this correctly, so correct me if I'm wrong here, you get commissions from selling the houses.
Correct.
And at some point, did Fotis request or mandate out of Group that you would reduce your commission to, I guess, share the love, kind of?
Correct.
Across the- And that would also be after the point when Michelle Troconis started working and assisting at Group, doing, I think, marketing.
Mhm.
And do you mean yes?
Yes,
You have to
sorry.
say yes, sorry, it's
Sorry, I
recorded.
apologize.
Thank you. So she would work at Group doing, taking pictures, marketing the property as well?
I believe so, yes.
Okay. And so she would get paid by Group as part of the employee.
I have no idea how she was paid. I was not there at the time. So I don't know how she was compensated.
But it was definitely, she was doing some marketing as well.
Correct.
Okay, for Group. And you also indicated that she was selling rugs. So she had her own business selling rugs?
I don't know if she had her own business, but I know she had some rugs and we had seen one and the whole plan was to come over and look at them.
Okay, and that was on May 23rd of 2019?
Yes, correct.
All right, so you get to, let's talk about the dinner party. You get to Fort Jefferson
Mhm.
and your plan was to see the rugs first? Were you
See
going
the
to
rugs
purchase
first.
them?
And I believe we did see the rugs first
Okay, and then you're going to stay for dinner?
for dinner, correct.
I know you talked about this on direct, but are you part of the water ski community pond?
I am not. I've been there. I have skied there, but I am not a water skier by any means. I'm a snow skier and a golfer, but not.
It's not for you?
I just, no.
Okay. And so you go there, did you purchase a rug from Michelle Troconis?
No, we did not.
And you stayed for dinner, and I think you discussed the fact that Fotis at the time, I just want to make sure I say it correctly, you said he was happy, laughing, it was a jovial environment?
It
I would
was, yes.
say? Okay. And he was, would you say optimistic
I believe so.
on May 23rd? Okay, and when you're.
I didn't hear his answer out loud.
I said, I believe so, yes.
And, at that dinner party, it was you and Beth
Correct,
and Hutch and his wife Erin.
correct.
Okay, did you know Hutch Haynes and Erin Haynes?
I had never met Aaron, but I had met Hutch a couple times.
Okay, so this party of the six of you, it wasn't a regular occurrence?
It was not,
it?
no.
Okay. And at what time did you know that Hutch and Erin were coming as well?
I think either when Fotis was leaving Jefferson to go wherever, or after he came back and then said he needed to get more meat for everybody. I think he forgot that we were coming. I don't know what happened, but I had no idea that Hutch and his wife would be there. I don't know if they knew that we were going to be there, but we just rolled with it and
So
had a good night.
You learned that night while you were already there or en route? Is that
Yes,
right?
correct.
Okay. All right. And at that night, you were socializing, talking with everybody, including Michelle Troconis?
Yes,
Okay. In English?
in English, yes.
Okay. And any part of the discussion that night talk about plans to murder Jennifer the next day?
No,
Any part of that discussion talk about plans to dispose evidence in garbage cans along Albany Avenue?
no,
Any part of that discussion involve plans about using the Toyota Tacoma and cleaning it afterwards?
No.
Okay, that's not something you discuss at a dinner party?
no.
Okay.
I'm going to object that last was argumentative and it's
Well, it's gratuitous,
gratuitous.
but that's not essentially a ground on which to object, but the jury knows the difference between a genuine question and questions that are gratuitous. So the court is not going to sustain the objection. The jury knows what it hears.
If I may, Your Honor, I will move on.
You may proceed, counsel.
Thank you. Just a couple questions about 80 Mountain Road, Mountain Spring Road. So if you're coming out of Jefferson Crossing and where you met Fotis Dulos coming, you were going up towards Jefferson Crossing? So you're driving up north?
I was on Eli heading north.
North.
Yep.
Okay.
And to make a right into Jefferson Crossing.
Into the-
Yep.
Okay, where would, if you're going up and you're taking a right into Jefferson Crossing, where would Mountain Spring Road be?
Oh, that would be well behind me.
Behind you?
Yeah, so behind me, and then that intersects Old Mountain Road, and then, no, is that, yeah, Old Mountain Road, and then you'd make a right and then make a left onto Mountain Spring Road.
Okay, was Fotis Dulos driving in?
He was going in the direction of Mountain Spring Road from Jefferson Crossing, but very close to the entrance of Jefferson Crossing, but he made a left out of Jefferson Crossing towards that direction.
Okay, so you kind of passed like ships passing in a night, is that right?
Yes, correct. Yeah.
Okay. Okay. Oh, Fotis Dulos didn't tell you he was going to 80 Mountain Spring Road,
No,
did he?
I had no idea where it was going.
No. And if I can just have one moment. I have nothing further. Thank you, sir.
Thank you.
Redirect.
Yes, you indicated that you didn't know if, well, you didn't know the Haynes were coming.
Correct.
Was Fotis somebody who, when he made social plans, was kind of like last minute?
Say sometimes yes, sometimes no.
You're kind of spontaneous?
Can be, yes.
Was this a formal or informal dinner that night?
I think it was just informal. It was what it was supposed to be, or what it, and I mean, it was,
Yeah, what was it supposed to be?
it was supposed to be go look at the rugs and then go get some sushi in Avon.
But that didn't happen.
That didn't happen. So it was go look at the rugs and stay at Fort Jefferson and have dinner there.
And who changed the plan?
I think Fotis did. I think Fotis forgot we were coming, and the Haynes, I changed the date originally, so he might have had plans on that Thursday. I didn't ask. He just said, oh, the Haynes, and so we were like, we're gonna stay here. We're like, okay,
You never did go out for sushi that night?
no.
You were asked a question by Ms. Manning about your opinion on whether Jennifer would ever leave her kids or disappear and leave her kids. Remember that question?
I do.
Did you have an opinion on whether, before she had kids, Jennifer would ever do something like that?
Before she had kids, if she
Yeah,
would do something
that
like
she
that.
ever disappeared? Were you aware of that?
Objection.
Well, what's happening now is this. This witness is now being asked about character evidence of someone who's not a witness. sustained.
I have no further questions.
Just briefly, Your Honor, if I may. So counsel asked you about Fotis always being late. I think he used the term spontaneous or always late, and it was kind of impromptu with regards to that dinner party. Right? Do you remember him asking you that just now? And so Fotis had a habit of being late all the time. Is that correct?
That's correct. Yeah.
Okay, I think you called it Fotis time before.
Yeah.
All right. Would it surprise you if he was told to be somewhere at 4:30 and he would show up at 3:30?
If he was told to be somewhere at 4:30 and showed up an hour early,
Yes. Would
That
that
would-
surprise you?
yes, it would.
Nothing further. Thank you.
Nothing else.
Right, you may step down.
Thank you.
Thank you very much.
The defense have another witness for this afternoon.
I have another witness about to arrive. I just asked.
She's not here? or
Yes,
he's
she is.
here?
She's in the hallway.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury? Could you please state your name and spell it?
Sure. Beth Reich, BETHREICH.
Right, you may be seated.
Good afternoon, Ms. Wright.
Good afternoon.
Were you subpoenaed to be here?
These guys make these slat wall out of, by the way, this is solid aluminum. So I'm
And I still use that name professionally.
Could you tell us what you do professionally?
Yes, I'm an executive at a medical device company.
Do you have any other side employment as well?
Not side employment. I have side interests. I'm certified as a research coordinator and a domestic violence counselor.
Can you just tell us what your educational background?
Sure. I studied opera at the Yale School of Music. I attended Quinnipiac University. I began my master's there as I had an accelerated program during my sophomore year. I graduated with a bachelor's, a dual major bachelor's in communication and marketing.
What town do you live in right now?
Avon, Connecticut.
With whom?
Stefan Reich and our collective children.
You have children and he has children?
Yes,
So how many children do you have separately?
I have 2 teenage boys,
And collectively, how many children are there?
3.
Did you know Fotis Dulos in 2000? Well, did you know Fotis Dulos when he was alive?
Yes,
Could you tell us how you met him?
I met both Jennifer and Fotis Dulos in November of 2014 when I went to the offices at Fort Jefferson Crossing, the Ford Group.
Who was living there at that time?
Jennifer, Fotis, and the 5 children.
Did you communicate at the time with Jennifer Dulos?
Yes,
Did Stefan as well?
yes,
Did you communicate with Fotis at that time?
yes.
Well, how would you describe your interaction with Jennifer Dulos during that time?
I'm gonna object, Your Honor.
How would you describe your interaction with Jennifer Dulos at that time?
Okay.
Ground.
Relevance, we're talking about 2014 interaction with Jennifer Dulos, the alleged victim in this case, Your Honor. It's not relevant.
Well, unless the inquiry is going to go beyond 2014, it's not relevant.
I understand. This is a preliminary when they met, and I'm going to then progress. So
Court will overrule the objection.
Do you want me to describe the moment I met her, or do you want me to
no,
describe the
I'm looking
totality
for
of my
the
experience?
general demeanor of the interaction.
Friendly, welcoming. She was very happy that Stefan and I were in a relationship, which was brand new in November of 2014. And the relationship expanded and our interactions evolved from there.
After that, did you become aware at some time that Jennifer had moved out?
Yes.
So before she moved out, was there any change in the way you interacted with her in terms of demeanor, what the relationship with you was?
The relationship became less of a slight acquaintance to a much more friendly relationship. We did socialize at dinners. I found her to be extremely supportive during some difficult circumstances in Stefan and my collective life. I found her to be very intelligent. One of the first times we had a more intimate conversation when we were alone at the home, she used the term effusive. And as a lover of lexicon, I kind of appreciated that a great deal. So the interactions were always warm and friendly and welcoming.
And when was the last time that you spoke with Jennifer?
I would say perhaps late, maybe very early 2017. I don't recall exactly, but it was certainly not after she left the marital home.
So before she left?
Correct.
Did your children interact and play together as well with her children?
Not on a regular basis. My children all ski. Stefan was a competitive skier. I'm a skier, and all the children skied. The Dulos children skied, and as did Fotis. So we would find each other together on the mountain, and we would ski together when my boys were very young.
So I want to be clear. We're talking about skiing on a mountain. We're not talking about water skiing.
Correct.
All right. So
Winter
in
skiing.
addition to water
I can't get up.
skiing, there was competitive downhill alpine skiing.
Correct.
And the Dulos children were involved in that.
Correct.
And Stefan's son was involved in that.
I don't recall exactly, but we would usually go as a family when the kids were little.
Did you ever meet Michelle Troconis?
I did.
What were the circumstances of you meeting her?
Fotis and Jennifer had left the house. Fotis and Jennifer had begun their, I don't know if it was legal separation at the time, but their separation. And to be blunt, we kind of got Fotis in the divorce, if you want to put it that way, because he was local and he and Stefan still had business dealings. And I think our first interaction was we had a sushi dinner together where we were introduced. And I think we were asked to be there for that dinner because Fotis wanted maybe a safe space to introduce Michelle.
How would you describe your meeting with Michelle? How did that go?
Fine, very engaging, worldly woman. Just getting to know somebody. It was friendly.
Did do you speak Spanish?
Poorly. I did when I was in Barcelona.
How long were you in Barcelona?
12 days.
12 days?
Yes.
Okay. So you didn't live there for a year?
No. We travel a lot and I try and learn the language for the country that we're going to.
Did you communicate with Michelle in English or in Spanish?
English.
Did you have any difficulty communicating with her in English?
No.
Were there words that you didn't know sometimes?
Nothing that sticks out.
Okay. So in any event, you socialized with Stefan and Fotis with Michelle
Correct.
over what period of time? Over how long a period of time?
From our primary meeting in 2017 until May of 2019.
When you said that you inherited, or whatever word you used, Fotis in the divorce, did you ever talk about his divorce in your presence?
He spoke about judicial matters and some frustrating elements about those judicial matters, but I think he learned very early on that neither Stefan nor I would welcome any negative commentary about Jennifer. So it was really mostly about his experience during the judicial process and his frustrations with it.
I just want to follow up on that. Had you expressed some disapproval of hearing negative things from him about Jennifer?
We never said it outright, but I think if anything was perhaps started or proffered, it was obvious that we weren't interested in engaging any type of communication like that.
Do you recall there was a specific invite to dinner with Fotis and Michelle in May, specifically on May 23rd, 2000?
I do.
What do you recall about the circumstances of that invite occurring? That is before the dinner itself. Like, how did the invitation get sent out and accepted, if you recall?
I think it was probably just a text request by Fotis to Stefan, and then we attended.
Do you know, or can you tell us whether or not Stefan had a habit with regard to being on time for things?
Stefan is militantly punctual, so yes.
Is that more, the way you said, is more so than yourself?
He's very, very punctual on all matters.
And if the invitation was for a specific time, did you and Stefan arrive on or before that time?
We would have arrived either at the specific time or a couple moments before.
Could you tell us, by the way, do you recall arriving at, or do you recall driving to Fort Jefferson Crossing for that evening, social evening?
I did not drive. Stefan was driving the car, but yes.
Do you recall seeing someone that is Fotis outside the house before you got there?
Yes, as we were pulling into the entrance to Jefferson Crossing, it's gated to a degree. He was pulling out and we didn't collide, but we were parallel, and we rolled the window down and said, "Hey, where are you going?" And it almost seemed like maybe he had forgotten we were going to be there. And then he said something about an errand and left. And then we proceeded to Fort Jefferson.
Was there anyone else either with him or following him out of the intersection there?
I do recall that there was a vehicle that was following him, but I don't remember exactly who it was or what vehicle it was. I'm not 100% certain.
During the time that you were involved with Stefan earlier on in this relationship, would you spend any time at the Fort Jefferson Crossing offices meeting any of the other employees?
Yes.
Do you recall whether the person that was following was an employee?
It could have been. If
don't
I don't know
remember?
who the person is, I don't exactly remember who it
Okay,
was. I'm
so let
sorry.
me move on from that. When Fotis said that he'd be right back, did he come right back?
I don't exactly remember the length of time, but he was back in due course, very short period of time.
Can you tell us when did you continue on and go into into Fort Jefferson Crossing?
Yes, after we exchanged communication with Fotis, we pulled Stefan's car through the porte cochere, parked on the French trellis portion of the driveway, and then proceeded into the house.
And just for those of us who don't know French, the porte cochere is the archway that separates the two garages on the left from the two garages on the right.
It's the archway, yes, the porte
Okay.
cochere.
So when you arrived, did you go right into the house?
I think we went to the door of the mudroom that was adjacent to the kitchen and announced our arrival somehow, and I probably brought something. I don't usually go empty-handed, so it was probably a bottle of wine or something, and put that on the counter. And I think Michelle greeted us in the kitchen. I
Do you
don't
recall
remember.
hearing her before seeing her?
Yes, the window was cracked. The window to the right of the door was cracked a little bit, and I heard her kind of speaking to herself.
In what language?
Spanish, I believe.
And when you came into the house, how did she react when she saw you?
Well, she knew we were coming because we were there specifically to see something of hers.
And what was that?
We were going to see some rugs, and she had been carrying them and laying them out. There were some in the TV room adjacent to the kitchen, so it was kind of like pathway from the kitchen to the TV room area. And then there were also some in the offices upstairs. And I imagine they were probably heavy, so she was probably a little flustered, and that might have been what I heard through the window.
Is the reason you were looking at these rugs at that time?
Yes, I actually have 3 of those types of rugs in my house, but they're cream and silver. And Michelle didn't have that in her inventory at the time, I don't believe. But it was an aesthetic we were interested in.
And were these being laid out for what? So you could look at them?
Yes.
You said some were laid out where were they laid out downstairs?
In the room adjacent to the kitchen, it had very large sectional, a television. And I don't recall any other details about the room.
Did you say you also went up to the office?
We did.
And were there other rugs to look at up there?
Correct.
Were they already spread out for you to look at?
Yes.
Would you describe her demeanor while you were there?
Yeah, she was telling us about the rugs. It was normal. She was happy we were there to see what she was selling for her new business and the support. She explained the details, where they were sourced from, and maybe where she was selling them currently, but I don't recall specifically.
Did you eat there that night?
We did.
Do you remember what you had?
It's a meal often repeated. So it was grilled meats and fresh French fries, because they had a French fry maker in the grill outside, and a Greek salad.
You say grilled meat. Was that a Greek thing you said it was a common meal?
Yeah, it was a common meal with Fotis at his home.
Okay. How would you describe the tenor of that evening in the meal?
Positive, jovial, relaxed.
Did another couple come?
Yes.
Do you remember who that was?
Yes.
Who was that?
Hutch Haynes and his wife. I believe it's Mary Ellen. I haven't seen her since that day.
If her name was maybe Aaron, might that ring a bell?
Thank you.
Yes, that's
Yes,
correct.
thank you.
Okay. And when they arrived, did anything change, or was it the same atmosphere?
No, it was the same atmosphere, just maybe a bit bigger.
Do you recall whether at any point Fotis left the house? You said he came back in due course, was what you said before, right?
Mhm. Yes,
Yeah.
I'm sorry.
Did he leave again to run an errand?
Yes.
Tell us about that.
He had prepared or taken some meat out for the dinner and realized that there wasn't enough perhaps for everybody, and went to buy some more.
Did he say where he was going?
Not that I recall.
Do you know how long he was gone for? the second time?
I don't know, but probably wasn't that long.
What were the subject, did people talk during dinner?
Yes.
What did they talk about?
General topics. Hutch has a ski pond he's very passionate about. So we talked about that, obviously. I had never met them before, so it was an opportunity to learn more about them. We talked travel and politics and current events and interests, the general kind of banter at a dinner.
Did that bottle of wine you mentioned get open?
Yes, and I believe there are a couple more.
All right. Were there any toasts that evening?
Yes.
Could you just describe that?
We learned that evening that, or I should speak for myself. I heard that evening that Fotis had been at Jennifer's home in New Canaan with the children, and that experience and their interpersonal reactions to each other was very amicable, which we were very glad to hear. And he had also stated that the custodial evaluation.
Objection, Your Honor.
Well, any testimony about what Fotis Dulos said about the custodial report or the investigation is not admissible. Follow up, counsel.
So without getting into what the custodial report said, what was the mood regarding the toast? What was the toast about?
I'm gonna object, Your Honor. This is clearly asking for hearsay.
Well, the preliminary question is, was the toast about what was in the custodial investigation or the custodial report? And then the court can act on the objection. If that's the question you wish to ask, counsel, you may.
Yes. What was the toast?
I don't know any words that were particularly said, but the general sentiment that I recall was a feeling of excitement that there was going to be positive resolution for them both during what I knew to be a very difficult custody battle, which despite which side you're on, it's very, very difficult for either parent and very difficult for the children. And the sentiment was that maybe this is going to end and there would be more peace.
And how did you react? What was your reaction? You happy?
Objection, Your Honor. Relevance.
Relevance, counsel.
Well, the fact that she heard something and reacted to it is the purpose of these.
Well, the jury can draw no probative value from this witness's reaction to what Fotis Dulos said, sustained.
Was there any negative comments whatsoever said about Jennifer during this?
No.
Was the entire evening a positive and hopeful evening?
Yes.
Was that true even after you finished the dinner?
Yes.
Was that true after you finished the toast?
Yes.
At any time, did you see Mr. Dulos act in any surreptitious or underhanded manner during that dinner?
No.
Anything that stood out as being odd?
Just that when we drove in, he was driving out and he almost seemed like he had forgotten we were coming.
Okay, but you said that wasn't odd for him.
I don't know if I actually said that, but it's often that in my experience with men, if you're a host of something, you might forget sometimes.
Okay, and how was Michelle's attitude that evening, or demeanor during that dinner?
Engaging, friendly, positive.
At any time, did you see her act in any strange way or leave the room in any surreptitious way?
Not that I recall.
Did she join in the toast?
I don't know how many hands were in the center, but I imagine she did.
Were people laughing?
I don't exactly recall.
Were people smiling?
Yes.
Do you recall whether you were the last to leave or whether the Haynes left before you?
The Haynes left before us,
So if you arrived at, what time did you arrive?
5 o'clock.
And what time did you stay until?
I think it was around 10:30.
And you said the Haynes left before you. Do you remember how much sooner?
I don't recall.
Did you, after dinner, did you help with anything?
Yes, Michelle and I cleared the table and worked on the dishes. And I'm not quite sure what Stefan and Fotis were doing.
All right, but did you chat with Michelle while you were doing the dishes?
Yes,
And what was the tenor of that conversation?
nothing negative, nothing that would bring me pause.
And was it upbeat?
Yes.
Do you recall?
Hi, everyone. Mark Barden here at Sandy Hook Promise. On December 14th, 2012, my 7-year-old son Daniel was shot to death in his first grade classroom at Sandy Hook Elementary School. The shooter shot and killed 26 individuals in about 4 minutes using an AR-15 military-style assault rifle. There is no place, there's no need, there's no practical application for a military-style assault rifle.
What it was like, how you felt, how it seemed that it was going. Now, 5 years later, with this case going on and all that has been in the media since then, is there anything in hindsight that you think was odd or about that dinner that you didn't bring up at all?
About that dinner, no.
Yes, or that evening?
No.
I have no further questions.
Well, do you wish to take the afternoon recess now and cross afterward?
That's probably a good point, Your Honor. Thank you.
Ladies and gentlemen, we will take our afternoon recess. Please do not discuss this.
Okay, I stepped away from the computer for a minute and I missed Are they on break or are they done for the day? Let's take a look.
Michelle was in the house that with 2020 hindsight would make you think differently about that dinner.
I'm sorry, can you repeat the question?
Sure, you've described what it was like, how you felt, how it.
Now and cross afterward.
That's probably a good point, Your Honor. Thank you.
Ladies and gentlemen, we will take our afternoon recess. Please do not discuss.
Okay, I didn't hear them say when they're going to be finished. I'm a little surprised. Hi, Kat. I got my phone in the other room because I was going to go get some soda pop, and I realized that things had ended. So I'm hearing myself in the other room. Okay, so let's just do a quick check. Looks like there hasn't been any jury questions over on Harmony Montgomery. They've been deliberating nearly 2 hours now. And let's see. Give me a moment. I'm gonna go get my phone so I can mute it. I'll be right back. Okay, AON says hi. Amusing incident. I went to grab my phone, and a package of Caesar salad dressing that you get in one of those salad kits had fallen off of the counter and onto the floor, and I didn't see it, stepped on it, so splattered Caesar salad dressing all up and down my leg and in the kitchen. So we need an expert on Caesar salad dressing spatter patterns. Okay, yesterday I saw a few interesting articles. Let me find one. This one was from yesterday. Okay, this one says Scarlet Lake transgender murder accused of had fragmented personality, including being a cat who would meow at friends, court hears. A transgender murder accused obsessed with violence and death who live streamed a sadistic killing of a cat, blamed an ex-partner. Oh, so it's not a person that was murdered. Scarlett Blake, 26, is accused of murdering. Oh, so she killed a cat and a person. Okay. Accused of murdering Jorge Martin Carreno, 30, used food to capture the family pet and kill it. Oxford Crown Court heard that Blake dissected the cat after killing it and removed the fur and skin and placed it in a blender. Prosecutors allege the killing is relevant to the murder trial as it shows Blake had a disturbing interest in what it would be like to harm a living creature. It is alleged that Mr. Carreno, who worked at BMW, suffered blows to his head, was strangled, and then drowned in the River Cherwell. Giving evidence, Blake blamed Ashlyn Bell, who lives in the United States, for making them kill the cat. I suppose it came to a situation where I didn't really feel I was able to refuse that request from her, where she asked me to do it for her, Blake said. It's something I very much didn't want to do, so I emotionally distanced myself from the animal to be able to do it. So it doesn't hurt me, otherwise she will and does when I don't listen to her. Okay, she's not sounding very coherent. It is something to make her happy and is something she wanted me to do, so I pretended to enjoy it, I guess. Richard Sutton, King's counsel, defending, asked Blake, smiling at the camera during the video. Defendant replied, It was a very choreographed laugh. I'm sure my face was not like that the whole time. Blake, who had pleaded guilty to a charge of criminal damage relating to the killing the cat, explained they enjoyed taking part in inanimate objects and seeing how they were put together. Okay. I guess I was just pretending the cat isn't real or sentient, Blake said. Blake explained to the jury they felt compelled by Miss Bell to kill the cat, which happened 4 months before Mr. Carreno died. There was a building up in her conditioning me to obey what she tells me to do, Blake said. She would tell me to do things on video call, like cutting myself or setting up a noose from the ceiling and putting my head through it. I would be rewarded if I did it promptly and followed instructions, and I would be punished if I did not. Blake described the details in graphic online chat between the couple as fantasy and for Ms. Bell's sexual gratification. The whole thing is a suspension from reality, the defendant said. For her, I'm sure it would have been arousing. For me, it is a reciprocation for her pleasure. Earlier, Blake had explained to the jury they were born in China and came to live in the UK aged 9. Age 12, Blake told his parents he was transgender, and since 17 has been on medication to block testosterone and took also takes estrogen supplements. Jurors heard that Blake had been diagnosed with depression when younger and a fragmented personality included being a cat for which Blake would meow at friends. Sorry. Mr. Sutton asked whether Blake had any other sides to his personality, and Blake replied, "There have been many that come and go." I would say that I would fit a textbook definition of dissociative identity disorder, and that there are no hard boundaries. For me, it is fluid. Blake of Crotch Crescent, Oxford, denies the murder. The trial adjourned until Tuesday.
Please be seated.
Okay.
That's what
Oops.
father does. All the defendants for a journey that we told you back before we took the view was going to be a journey that you weren't going to forget. It has been a long couple of weeks. You have been incredibly attentive, and we are very, very appreciative of that. One of the things you heard just a moment ago from Attorney Smith was that she doesn't get the opportunity to come back up here and talk again. That's true. It's called taking turns. It's something that parents teach children. Beginning, state has to go first, defendant has to go second. At the closings, defendant has to go first, state has to go second. Something very simple that parents teach children. One of the other things that they should teach is if you're going to quote the defendant, if you're going to quote a witness, you have to make sure that you're accurate. So I'll apologize in advance. But let's quote people accurately. I fucked up. Again and again and again. I fucked up. I fucked up. That's what the defendant, his language that he used when he told Travis Beach the night he got the U-Haul, the night that he disappeared Harmony's body to whatever place it is now, where he knows it is right now to this day. His words, I fucked up. Not she, not we, not Kayla. I fucked up. Singular, personal, solo. That's the defendant's words. Defense counsel got up here in openings and said that you'd hear evidence that Adam Montgomery was out in the middle of the night doing his business when something happened and Harmony died. If that were so, the defendant never would have told Travis Beach, I fucked up. Adam Montgomery was no loving, caring parent, but an enraged tyrant who had no business being around young Harmony. So together, let's look at the actual evidence, the actual quotes of what you saw and heard as we look at all of the charges that you're going to deliberate on that encapsulate what the defendant did do, and talk about the evidence that you've seen tells you what he committed. And we'll start first with what the defendant's telling you in opening arguments, and now that you can and should find him guilty of abuse of a corpse and falsifying physical evidence. Let's set that as the baseline. Let's start there. Let's see what that actually means before we look at how he committed each one of the crimes charged, not just the ones that he feels are going to distract you from the rest of the nightmare that he's responsible for. Who carried Harmony's body away from the broken down car in the duffel bag, hid her outside of Colonial Village while they stayed in Anthony Badero's blue Audi for 2 nights, put Harmony under a ramp and then in a van and then in this cooler for weeks at Christina Lubin's house, into the CMC bag, into the walk-in cooler at Portland Pie Company, in the fridge, in the freezer, defrosted her in the shower, consolidated her body yet again, brought her to the Econo Lodge, tricked his friend into renting him the U-Haul, and then dumped her body somewhere. All to make sure that the evidence that could have been brought before you that shows that he's responsible for having murdered her would never be found. And he says you can and should find him guilty of those 2 crimes, of abuse of a corpse and falsifying physical evidence for this. He doesn't dispute this. The defense said all of that in their openings, that the defendant did both of these 2 bolded things. Since day 2 of this trial, opening arguments, you should then consider not only all of the testimony, but also all of the corroborating testimony about all of those charges, those 2, falsifying physical and abuse of a corpse, to be true. So let's make it very, very painfully clear from the indictments that you're going to be considering for falsifying physical evidence and abuse of a corpse, making this Harmony fit into this and disappearing her body in the condition that it could not be found for a trial like this one. The evidence was there, and the defendant's counsel professed to you that he's not disputing that, not saying he didn't commit these crimes. So you can check these 2 off the list. And with that, you got to remember the defendant gets no credit for this. He says that you can and should find him guilty of these, but he's not taking responsibility for them. He hasn't admitted anything. He's not taking responsibility for anything that he did. His argument to you is not because he's taking responsibility. It's tactical. He admits what he can't deny. And he denies what he can't afford to admit. He cannot deny each and every single one of these facts that were presented to you. That she died on the 7th, that he brought her in a duffel bag to Colonial Village, stored her under a deck, into a red cooler, in the closet it fit, in the ceiling it built. It's her blood in the ceiling at the Fit Shelter at 177 Lake Ave. And his fingerprints in the ceiling. Remember, left-hand prints in the ceiling. The only other person being poor Mr. Mondrag, the drywall installer. Into the CMC bag to the Portland Pie Company, over to Union Street, consolidating her body even more, bringing her to the Econo Lodge, tricking Travis Beach, and dumping her body so it wouldn't be found. The argument that the defendant is making, he had to make. His concessions don't mean he's taken responsibility for these crimes. It doesn't mean that he's a man of principle or restraint, nor does it give his argument any credibility that because I concede all of this, well, the rest of it must not be true. The whole thing's true. And he's taken responsibility for none of this. So again, baseline, first things first, before we move on, these two charges and the charges that his counsel argued can and should find him guilty of, they're there. That's done. And that's the tip of the iceberg. It's all of the charges. Every single one of them has been proven by evidence, not emotion, beyond a reasonable doubt that the defendant is the man who did all of these things. And that's because you saw the evidence. You went on The View. You saw witnesses take this stand and put themselves before you, and you looked them in the eye. And the same common sense that you use every day to tell whether somebody is feeding you a lion, a bull, or not, you used with those witnesses. And because of that, you know that this is true. Because you heard from people like Kevin Montgomery, Nick Ahern, Katie Moran, all talking about the defendant telling them in July about the worst thing he had ever done up until that point. You heard from Kayla, 2 days from Kayla, and all of the other witnesses that corroborate her, how he beat Harmony, this 35-pound child. Remember, Nurse Travers told you that she was measured just back in June before the July incident occurred. 35 pounds, 5 years old, 35 pounds. And you heard from all those witnesses, especially Kayla, about why he beat Harmony to death, when he beat Harmony, and how he beat Harmony. And you vetted what she had to say. And you saw the rest of the injuries that he incurred, and all of that was corroborated by the other evidence presented. Corroborated in ways that we'll explore that the witness never could have possibly known there was other evidence out there that supported them. Not when the defendant started telling investigators what happened and how the defendant beat the life out of Harmony. And then beat and manipulated and controlled Kayla afterwards to make sure that she stuck to the story so he would not be held accountable and the evidence of his crimes would not be found. So when he says that you can find him guilty of these, understand that these two are but a part of the whole of his criminality, of how he murdered Harmony as well. When he said this to Travis Beach, it wasn't for part of that. It was for the whole of taking Harmony's life and beyond. Don't forget what he's saying that you ought to convict him on as well. That the falsifying physical evidence and that the abuse of coverups are unto themselves evidence of the crime of murder. He's a murderer. That's getting rid of evidence. That's what murderers do. They get rid of evidence that would show others what they've done. They think no body, no evidence, no conviction. They silence witnesses into staying silent or even perjuring themselves so that the witnesses don't tell others what the murderer did. Because murderers don't want to be held accountable for their actions. Murderers want to get rid of the evidence. They don't mind abusing the body so that the evidence of how their victim was murdered can never be found or used against them. They clean bathrooms with ammonia after they get rid of the evidence, like this defendant did. They clean out the plumbing lines, like this defendant wanted to do. They desecrate and hide the dead so that the body cannot tell the story of how they died to the living. That's what murderers do. That's what the defendant did, because he's a murderer too. Now, let's really start now. Let's start and talk about what he did first to Harmony. Excuse me. Let's talk about what happened in June. Let's talk about the second-degree assault. You will likely never forget Kevin Montgomery's testimony as he was sitting up here, taking his time to thoroughly make sure he answered truthfully and recalled to the best of his recollection. And you are never going to forget how he described Harmony's face when he flew home from Florida, having been there in July, come back on the 22nd to see Harmony in the house in the kitchen. And we saw him relive that moment for us, admitting that he asked her, quote, "Oh my God, Harmony," or "Oh my fucking God, Harmony, what did you do to your face?" End quote. And how he told us Adam answered the question. Not Harmony. Adam did. She didn't do anything. I bashed her around the fucking house. That's not disciplining a child. That's not pulling her away or jerking her and not protecting someone else. If it had been, The defendant never would have said this when Kevin asked Harmony what happened, would he? Kevin Montgomery told you he was subpoenaed to be here. He did not want to testify against his nephew. And you saw it on his face that he remembered what the defendant said he did. Not Harmony answering the question. The defendant answered it for her. And remember how Kevin said the defendant said this. Another moment, probably not going to forget. When I asked Kevin about how the defendant said he bashed her around the house, Kevin, you'll recall, said, quote, like a cocky son of a bitch. Nick Ahern told us he saw that black eye and how bad it was. And what did the defendant do? Lied to him. Nick told us how the defendant told him that it was from an injury from playing soccer. Nick told you he only saw it for what? How many seconds? 4 seconds. Only saw it for 4 seconds. Saw how bad it was. He described it as being pretty intense, that it was concerning to him, and that the defendant let her be outside for all of 4 seconds before the defendant told her to get back inside. And what did Harmony do? She obeyed. Nick saw him walk Harmony right back through the front door and then shut it. And so why did Nick hide Harmony away that day? Because he couldn't let a 5-year-old outside on a summer day, could he? Not when her face showed the mark of the assault that he had delivered on her. Shows everyone in the neighborhood, along with Nick, evidence of what the defendant did to her. Katie Morin told us that the defendant used other words to describe that day and what he did, besides bashing her around the house. Did she say a jerk? Did she say a grab? Did she say a yank? She did not. The defendant told her it was, quote, the worst thing I'd ever done, end quote. And that he had supposedly backhanded her. That tells you that the defendant knew how badly he beat Harmony that day in July, that the defendant called it to Katie Morin the worst thing that he had ever done. And the evidence from the multiple people who saw how bad this was and who heard the defendant describe either inflicting it upon her or hiding her. Don't forget, we also have Demetrius Saros. When he first went to the house, was he able to see Harmony? He told you. Only from feet away, as the defendant was hurrying up and getting Harmony in the car and driving her out of there. And even a week later, when he finally does get to see Harmony, she still has a mark on her face. Finally, you've also got Kayla Montgomery, who told you she overheard the defendant's conversation with Kevin Montgomery and then confronted him because he told her it was from a lightsaber that one of the boys had been swinging around and Harmony got hit in the face. And she confronted him about it and said, you said it was from a lightsaber. He said, yeah, no. What I said to Kevin was correct. He admits that he lied to her before when he told when he told Kayla that Harmony got hit by a lightsaber. More evidence that corroborates that what Kevin said happened. His conversation with Adam, where Adam admitted to hitting Harmony in July, did happen. Simply put, from multiple witnesses, from the defendant's multiple confessions, he committed the crime of second-degree assault on a 5-year-old in July of 2019. And of that, there is simply no doubt. That being said, now we can move on. Who and where and why Harmony was killed? Let's go through what the evidence showed us, one thing at a time. We saw that it was not alone with Kayla, not in the Colonial Village parking lot in the middle of the night, where Adam had gone to go do his business. Not that it was something that you heard that had happened. It was the defendant in the car on the morning of the 7th with his fists. And it was cold. We know it was cold. So cold that Padero's car died that night when they moved over into the Audi. Adam wrote to Matt Gendron, remember, that they were freezing. Cold enough so that Kim Frayne went and gave them the battery pack to help give them the jump start. So we know it must have been cold enough that day that blankets in the back of a car did not appear out of place. Kayla told us how the accidents were happening, and yes, something had happened the night before, but she told you the night before was when the defendant first hit her. Why? For another accident that Harmony had had in the car. An accident that Kayla did nothing about. An accident that the defendant did nothing about and told Kayla to let Harmony lie in it. Kayla told you what it smelled like, and she told you to your face that she still did nothing about it. And in the morning, things were still the same. Kayla described for you how it started up again. It was still dark outside. She told you the first blow in the morning, it was still dark outside. We know that. Why? Because it's December 7th. because it's before they get to the methadone clinic, and we know that the check-in times there are 7:05 and 7:09, and you know how dark it is in December, just a couple of days away from the darkest day of the year, December 22nd. When the defendant gets out of the car, goes in and gets his methadone, and then comes back, he finds Harmony has done it again. The smell of her inability to control her bladder and her bowels, something that she used to be able to do just fine for years. It's back again in his car again. The last place that he has, the only place that he has. And what does the man whom Kayla saw be so rageful do? And remember, that rageful wasn't just seen by Kayla, wasn't it? We heard from Rose Smith, the driver, years later, 2021. She told you that after giving Kayla a ride to the methadone clinic with Adam and coming back, that Kayla had had bruises that day, terrible black eyes, and that she tried to give her phone to Kayla. And her words were that when he wrenched that phone out of her hands, he told her, "You are not giving that phone to my wife." And she described his face. How? A look of pure rage. What does that person do when they get back to the car after their methadone and Harmony has soiled herself again? All he has is his car and his rage and his fists. And Kayla described for you how that went on. For the length of time that the same length of time that you took driving from the clinic here on Market Street up to the Burger King on Hooksett Road, you drove that drive. You know how long that is. And as the smell continued, she described that the hitting continued. And Harmony took blow after blow until she was moaning. And the defendant points to the fact and says, well, other people, they should have been able to see in the car. It's cold. It's dark. We know there's snow on the ground. Snow in New Hampshire means salt, which means the windows probably look the exact same that yours and mine did this morning. It's not easy visibility. Plus, think about it. Doesn't take a lot to be able to punch down on a 5-year-old, 35-pound child and make sure that it's below the windows. Not for him. Not for Adam Montgomery. Not against Harmony. Not in that car. And you saw from the Walmart video and the video from Officer Stanzel, when they first approached the defendant, when he was trying to find where Harmony was, you saw from that how the defendant looked. Remember him at Walmart. He's not a small or a weak man. He wouldn't need to use much power to inflict deadly force upon Harmony's skull. And you heard it wasn't from one blow of his arm, but several. Take a moment. Let's just take a break and talk about something that defense brought up. The fact that there are other children in the car, and why wouldn't they have been screaming and yelling? I remember that fun catchphrase she tried to get Kayla to say, a cascade of chaos would have ensued. We know young children adapt to their environment like nobody's business. They're frightened by new faces, they're frightened by new experiences, or the unexpected, but they're not frightened by something that's familiar. Why would the other children cry if Harmony had been getting hit and punished in the car? After all, this was the second time in less than 12 hours that they would have seen this if they were awake. They would not have been unfamiliar with his rage towards Harmony in that car. The defendant's theory that punishing Harmony for soiling herself would make the other children cry implies that this is unfamiliar to them. And the evidence shows that it is not. Kayla rejected that cascade of chaos every single time it was proposed to her. And both Kayla and common sense tell you that that makes sense, that that's true. And when they got to Burger King, the damage at that point had already been done. As Kayla told you, Harmony laid under the blanket. No one went to get help for her. Not the defendant who beat her, not for Kayla either. And what did the defendant say in that moment? Words matter. I think I hurt her this time. This time. This time, I think I hurt her. I think I did something. Why say this? Because he didn't do nothing. He did something. He took her life in rage over a bathroom accident. And he admitted in his opening that you can and should find him guilty of abusing her corpse and falsifying physical evidence for what he did afterwards to get rid of the evidence, get rid of her, get rid of the evidence that would have shown he murdered her. But it was the evidence of his crime of beating her. I fucked up. I think I did something. I think I hurt her this time. That's what he believed. You saw Kayla testify. You heard for 2 full days practically while she was on the stand, having to tell you what she saw having happened. And Kayla did nothing. She did nothing. She did not parent Harmony. She did not clean Harmony. She did not change Harmony when she soiled herself and the defendant told her to leave her in it. She didn't stop the defendant. She didn't try to get Harmony help. She didn't call 911. She didn't yell out. She didn't run out of the car. She didn't disobey the defendant. She's not seeking help. She's not seeking attention. He went through the trunk to get her, not her, because she did nothing. Later, she didn't betray him until after she even lied in grand jury and committed perjury for him. She didn't lift a finger. She did nothing. Nothing at all. The defendant wants to have their cake and eat it too when they come to describe her. She's an abuser, but she did something in the middle of the night. She didn't see anything here, but she saw it all. She wants the defendant. Oh, she doesn't want the defendant. Believe her grand jury testimony, but don't believe her grand jury testimony, the part where she said she lied. That part you should actually believe, even though she's telling you it's a lie. Want to have their cake and eat it too when it comes to her testimony. Well, you know, she would have been really conscientious when she was shopping for diapers. Because that's, if you're homeless, yeah, that would make sense. You want to go where you can get the cheapest price. She's a drug user. She's homeless. And for Harmony, she does nothing. They want to argue, well, she would have had this instinct to protect that child. Oh, but she did something to her in the middle of the night. She did nothing. We are tested, all of us, just a few moments in our lives to do the right thing, where our character as human beings is tested to do the right thing. And on this test, December 7th, with where Kayla Montgomery was back in that life, she failed. At grand jury, she failed. She still obeyed him. Even though he had run off to Maine with a second girlfriend since then, she still obeyed him. Katie Morin told you that back then, Kayla would have done anything for the defendant. That's what her protector did to her. He had her conditioned so well, physically and mentally, that she kept his secret, and she did nothing. You saw that in her testimony when she told you about doing nothing. And she told you about not stopping him from hitting Harmony. And she admitted unashamedly, without reservation, she didn't try to take Harmony to the bathrooms to clean her up. She didn't try to get her help. She did obey. She took Harmony's body to Portland Pie when he told her to later, sitting her between her 2 children in the stroller for that 15-minute walk down the street. But she did nothing. You don't have to like her to believe her. You don't have to like what she did. You may have very good reasons for hating her, but that doesn't change the fact that she saw the defendant beat Harmony to death. That doesn't change her credibility on telling us what the defendant did. Just because you believe that her failure to do the right thing is despicable, it doesn't mean that on this, she's not credible. She actually tried to humanize this guy. Remember her testimony? She cried. And she said to you and admitted she still cares about him. Her in prison, Harmony somewhere, only he knows. And she still cares about him. And she admits how she did nothing for Harmony. If she was singing for her supper, like the defendant suggested in their opening, she wouldn't have done that, would she? She'd have an answer for every question, an excuse for every moment that she did nothing. She didn't have that on the stand. She would never have admitted that she didn't take the kids to the bathroom or that she let Harmony sit in it that night. And yet she did. That's someone who's not making up a story to make herself look better, is it? She never would have admitted that when Harmony is covered by the blanket as they get their food from Burger King, that she unceremoniously dumped a breakfast sandwich on top of the blanket. Harmony can open that herself. After the defendant had covered her and smashed her face. And yet, that is what she told you happened. Kayla admitted to you that she did nothing. It's not the face of a person who's trying to make themselves out to be the saint and the defendant to be the devil. That's certainly not a master criminal schemer trying to exonerate her own behavior, as you just heard in closing arguments. She is not like the defendant. She's not admitting that what she can't deny and denying what she can't afford to admit, because if she did, she would have never admitted to her failure to act to protect Harmony. She would have never denied doing the small things. She would have claimed, oh, I did do those. I tried to redeem myself. And how she comes across, how she testifies. What she is a battered woman admitting an inconvenient and terrible truth, that she failed in a moment of life when her character was put to the test. She did nothing to help Harmony, nothing to stop her. She didn't kill her. Only the defendant did that. So when defense counsel says that it was Kayla who put Harmony in a duffel bag in the trunk and told Adam about it later, you heard and saw Kayla testify. She did nothing for her. Not a thing. And you can't get something from nothing. And the defendant's promise at openings that you'd see she did something remains exactly now as it was then. And it's a false promise. You've seen that theory with evidence presented to test it, and it is still without support. It is still without corroboration, and it is still unreasonable to believe because it was the defendant who did something. When you consider Kayla's testimony, don't consider it alone. Consider it with all of the facts that go along with that testimony. Facts such as that she does have an agreement to tell the truth. Defense counsel questioned her and argued that, well, she had to give the police a lot more to get out of the additional lies that she said in grand jury. But remember, if she doesn't tell the truth, all of this comes back on her. It's back to square one for her. Her agreement is null and void. But the evidence that you saw, how thoroughly the police investigated this case, where Harmony is, location after location after location in New Hampshire, Massachusetts, 900 plus pieces of evidence to help find out what happened, has only corroborated Kayla about who killed Harmony, about when she died, who hit her, who mangled her body, and who dumped her where she is now, somewhere between here and the Tobin Bridge in Massachusetts. Corroboration, big, fancy, 5-syllable word that stands for evidence that supports that a statement is true. If you just had Kayla's testimony alone, with her truthful testimony on the elements of the crime charged, that would be enough for you to go ahead and find the defendant guilty of all the charges. But you don't just have her testimony. You have so much more, because every witness, 50 witnesses that came in and testified to you about and provided evidence, provide some corroboration for Kayla's account of what happened in ways that she never could have known. And that includes testimony and evidence that corroborates her on how Kayla died, and how Harmony died, and why the defendant killed Harmony, why her body was desecrated, how Kayla was silenced for so long, and how the defendant discarded Harmony like trash so she wouldn't be found. Let's look at just one example. How do we know that Kayla's telling the truth when she told us how the defendant tried to induce or cause her to stick to his story, to not testify, to not tell people how he murdered and disposed of Harmony? How do we know that Kayla's telling the truth on that, tampering with her as a witness? It's because the evidence corroborates it. Nicole Giles told us that Kayla was still at the Fit on Lake Avenue, the Families in Transition Shelter, when she saw bruises on Kayla's body. This is back in January of 2020, before Harmony was ever known to be missing. And Kayla is admitting to Miss Giles that the defendant is beating her. And she, what? She asked Miss Giles not to tell anyone. Having just been homeless, now living in a transition shelter with 2 younger children, and having been tested before and failed to get help for a child, she stays silent. She obeys and sticks with the defendant's story. Despite her abuse later, we see that as well from the testimony of Rose Smith, who was giving her that ride for methadone that morning, saw the beating that Kayla had taken the night before. And as she again saw pure rage in the defendant's face as he came and wrenched the phone out of Rose's hands, saying, "You're not going to give my wife that phone." So much so that when you heard and saw Rose testify, you heard her say, ever since then, she refused to drive them around anymore. That she carries pepper spray now. And she said, quote, "Something I will never forget." Kayla is under control and doesn't say what happens to Harmony throughout that time period. And he believes that she's helping police. You heard testimony about how he believed the police were listening in on him and tracking him, and that he was ripping light fixtures down, that he was breaking thermostats and electronics. Kayla told you that he was paranoid that she was working with police and was being listened to. It's not a sign of mental illness. It's not a sign of being sad. A sign of guilty conscience. A sign that you want to continue to exert control, and you should think of it as such. That's corroborated by Dennis Cloutier. Remember the handyman at 644 Union Street? He saw the ripped down electronics, the broken thermostats, and he made the repairs. We also see more of that witness tampering from the testimony of Tara Hilbert next door on Orange Street, when Kayla finally does escape physically the clutches of the defendant, to the cycle of abuse that he had perpetrated for so long. The defendant didn't want to be found out. And since Kayla, excuse me, he silenced Kayla because he didn't want to be found out what he had done. And you know that from the very beginning. Don't forget the Facebook messages to Travis Beach. The U-Haul was still out there. What did he tell Travis? The day after, the next morning, when he's trying to find out, Travis is trying to find out where the van, because it's supposed to be back. What does he tell Travis right then? Please don't message me stuff like this on Facebook again. Just like getting rid of the body and destroying physical evidence, convincing witnesses to what you've done to stay silent. That's what murderers do. That's what this defendant did. They silenced them into staying silent. And the defendant did that for so very long. He made sure that it was his story that was being told. He continued to tell his story and different variations of it to everybody. His lie that he created. To Christina Lubin, remember, this would have been the first day after they got booted out of Anthony Badero's Audi. At Christina's place, tells her, I dropped her off in Massachusetts with her mother.
Okay, it looks like they are back from lunch, and somehow my somehow I didn't catch it, so I'm trying to find it here. Okay, here we go. We'll save the rest of the closing arguments for later.
Judge, this is actually about another witness, so I don't know if,
Disregard another witness?
yes, I don't know.
To be heard or already testified?
Neither, actually. I just wanted to put something on there. I don't know if the
You may
witness
be
just set
seated.
out for just,
That's fine.
then the jury's.
Oh, that's right. All right.
Can we approach it sidebar then, Judge? Thank you.
There is a question about, part of the defense has been that Fotis Dulos was telling everyone he knew, including Michelle, how good things were going. Now that the custody study came out and how optimistic he was, I thought the court's ruling was we couldn't get into the actual custody study. Whether what Dulos said was true or not, it happens to be, because the court is aware, true, but whether it was or not is not the issue. It's the fact he said it, so it's not being offered for the truth. It's being offered to show the reaction that he's telling everyone this. And that's why Michelle, it would negate the idea that she thought that this was going to go on and on and on, despite the fact that at least there was all this optimism being said literally the night before the disappearance. So I just want to put it on the record. The court has not allowed that. I'm going to ask the court to reconsider, because it is sort of part and parcel of the defense to be able to elicit what Dulos was telling people about it. It's going to come up at least with one other witness. And so that's why I asked that the court reconsider that. restriction.
Well, the gravamen of the offer is that on the 23rd or the 24th, right now it's the 23rd, he was happy about the way things were going. There need not be a mention of the custody report. There's already evidence that he was optimistic about the way things were going. That's been testified to more than once.
I don't disagree. What I'm asking, though, is the court is also precluded to have any witness talk about that he was at least talking about the proceedings, that how things were going in the court was optimistic. And I would have asked this witness whether they toasted to new beginnings as a result of those statements about the actual court proceedings, not that he personally felt it, but he believed that the court was going his way. That's the purpose of it.
Well, if that's the offer, there need not be mention of the custody study. Were things going his way in court, according to him? Yes.
Yes, I thought they objected to even mentioning court, and that's why the court, I thought, precluded that question. I don't have to mention the study at all.
Well, if the question is whether he thought things were going well in court on that date, without reference to the custody study, the court would allow that.
All right.
But any effort to pry open what was happening in court and what was filed in court, other than the court understands that there will be a witness who will discuss what the filings were and when those filings were done. But again, it's really the same question. Was he optimistic about custody with his children? Yes. Was he optimistic about the way things were going in court concerning custody? Yes. It's the same question.
Okay.
You can bring the jury out, please. Will the counsel stipulate, please?
Yes, Your Honor.
Yes.
Thank you, Your Honor. Good afternoon, ma'am. How are you?
Good afternoon.
Just a couple of questions I had. I actually just wanted to ask you, counsel asked you if there was anything odd or anything in hindsight about looking back at that dinner party on May 23rd. And I want to ask you about your answer. You said no, but you clarified that with saying at the dinner party. Was there anything else that you thought was in hindsight odd or different?
Not at the dinner. Everything I testified with respect to interactions and feelings, et cetera, at the dinner was completely accurate. The question of hindsight in this case, how it is relevant to that statement is after the warrants came out and all the circumstantial evidence came out pertaining to Fotis, it seemed as though perhaps
Well, I have to object. As an opinion, based on what she read about, I would argue it's outside the scope of direct, irrelevant.
Well, the court understands the testimony to be hindsight testimony. Overruled.
you can continue, ma'am.
But Your Honor, the hindsight had to do with the dinner, not about now 5 years later, what she thinks.
Your Honor, he specifically asked her in hindsight sitting here today. I'm just asking what she meant by her statement, and she has a right to answer that.
Well, the question is not whether the witness has a right to answer. The question is whether the question is admissible. Necessarily convinced that hindsight referred only back to the dinner. So in other words, the court does not recall whether hindsight referred just to the dinner on May 23rd or hindsight referred to anything.
I'll ask the court then to review the testimony because that was the question, and that's what I asked about even now. Was there anything about the dinner that evening
that arises? Hindsight about anything, just at any time, is not going to be admissible. Hindsight about May 23rd will be admissible. So the court's understanding is the limitation that is looking back now, is there anything about what was done on the 23rd, anything you noticed that you're now thinking about that you didn't think about on the 23rd of May, 2019? Because what the court wants to avoid is this. Looking back now after you've read media reports, watched media reports, is there anything about Fotis Dulos now that you're thinking about in hindsight that essentially you didn't think about that on May 23rd? And the reference could refer to something Fotis Dulos did back in 2014 or 2016. So the court, in fairness, wants to limit that testimony because it may be unfairly prejudicial to tag any particular time in the acquaintance between Ms. Reich and Fotis Dulos. So if it concerns May 23rd, 2019, the court will allow the question.
Thank you, ma'am. With respect to May 23rd, 2019, is there anything in hindsight that you thought was different or odd?
In hindsight, what sticks out to me is the dichotomy of the positivity of that evening and what subsequently occurred. And again, with the benefit of hindsight 5 years later and continuing to process that concept, that dichotomy becomes more pronounced.
And this was the first time you had met Michelle Troconis?
No.
No. When did you first meet Michelle Troconis?
In 2017.
And you had gone out to dinners with them?
Correct.
And you had gone eaten at Fort Jefferson Crossing?
Correct.
It's the first time you met the Hayneses? Is that
On
right?
May 23rd,
23rd?
2019 was the first time, yes.
Okay. And that night there was the toast, and the toast I think you testified was because things were going to end. Was your testimony, is that right?
I believe I testified to the fact that there was going to be a positive resolution for both parents, and much of the negativity that affected all parties, the children and the parents, and the extension of the family would end. That was the purpose of my statement.
All right, thank you very much.
I just have a few questions. When you talked about the positive resolution that you were talking about on May 23rd, 2019, was that specifically upbeat about how things were going in court, according to Mr.
According to Mr. Dulos?
Yes.
Yes.
And was it optimistic for Mr. Dulos about how the things were going into the future, that he would be spending more time with his children?
Correct.
No further questions.
1 second, Your Honor, if I may. Nothing further, thank you.
Ms. Reich, you may step down.
Thank you, Your Honor.
Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury? Yes, I do. Please state your name and spell it for the record. I'm sorry, what? Say your name and spell it for the record. Cheryl Briere, Cheryl. B as in boy, R-I-E-R-E.
Good afternoon, Ms. Briere.
Hi.
Would you please indicate to the members of the jury what your profession is?
I'm a hairstylist,
How long have you been a hairstylist?
25 years,
Could you tell the jury where you practice your trade, your profession?
in Avon, Connecticut,
Where do you live, by the way?
Granby, Connecticut.
Do you know Michelle Troconis?
Yes, I do.
Could you tell her how you met Ms. Troconis?
I was working at a salon on 44, and she came in and wanting her hair done, and I just happened to be the girl sitting at the front desk. So we just started chit-chatting, and I said, well, why don't I book you with me? And she came in a couple days later, I guess. And I started doing her hair then.
When you say 44, you're
Route
referring to
44,
Route
sorry.
44?
Route
And-
44.
And
Avon.
does Route 44 have another name in Avon?
Main Street?
Albany Avenue?
Albany
maybe?
Avenue, yes.
Okay.
Yes.
And you were a hairdresser. What year was that? Remember?
That I started doing hairdressing?
No, that you
Oh,
met
that I
Michelle.
met Michelle? 2018.
Do you recall over the course of the next year, couple of years, how often did Michelle come into the shop to get her hair done?
Probably every 3 to 5 weeks.
Did she usually book with you
Yes, always.
as her hair stylist?
Yes, always.
Do you recall whether you saw Michelle during the week of May 20th, 2019? That is the week before Memorial Day weekend.
I can't specifically say to the date, but I think she was in on a Saturday to get her hair done.
Do you recall reading or learning something about the disappearance of Jennifer Dulos, the wife of Fotis Dulos?
I found out on the news when everybody else found out on the news.
Before you found out about it, did you see Michelle Troconis that
Yes, I
Saturday?
did. Yes.
So would it
So
have
I'm
been?
going to say like maybe a week before I found out I had done Michelle's hair.
Right. So what do you, if the day that, do you know when you found out?
It was like a week later when when it came out on the news. I'm going to say a week and a half later.
All right. And this was, you're saying a week before that you saw Michelle?
Yes.
If I were to tell you, just to get orient at the time, that the allegation was she disappeared on May 24th, 2019, on a Friday, what day would you have seen Michelle?
Saturday.
The next day?
Yes.
Would you just, how many times would you say over the previous 2 years had you met with Michelle? Seen?
The last 2 years?
Before, no,
Oh,
before that day.
before that. Like to have her hair done every 3 to 5 weeks. We became friends. We did some women's small business things along the way to promote women in small business.
What kind of business, did you have any business interaction with Michelle during
Yes.
that time?
One of them was she sold rugs. We put her rugs in our salon. I bought several rugs. I have a little side business without wine. So we had a little wine tasting at another friend of ours shop. So, just promoting small women in business.
That Saturday, what was the reason that you were in contact with her?
She came to get her hair done.
Did you in fact cut her hair that day or
Yes.
trim her hair, whatever, style her hair?
Colored her hair, yes.
Okay. And would you describe her demeanor and how she was on that occasion?
Michelle is always happy. She's just a positive person. I never see her mad or anything like that. She's just always uplifting. She lifts other people up.
Let's talk about May 25th, 2019.
Okay.
That day.
Okay.
Was there anything unusual about her behavior that day?
No.
Do you recall what you were talking about with her, subject matter?
Your Honor, I'm going to object at this point. Relevance, hearsay.
Well, the defendant's demeanor one day after Jennifer Dulos was missing is relevant. The topics that came up are also relevant, but the court is not going to allow testimony into the substance of the topic. So overruled.
Ms. Barrera, do you understand the difference? But I'm not asking you to say what she said, just what topics you were talking about.
We always talked about family and the kids. What are you doing this weekend? That type of thing.
Was she at this point happy or sad
No, she was always happy. She was happy.
on that day?
Yeah. Yep. Yep.
Do you know what time her appointment was with you?
That I can't,
Was it in the morning?
honestly, I can't say.
All right, thank you.
I mean,
don't
if you want to
feel-
know my hours, I could tell you my hours were 9 to 1, if that helps.
Oh, so on Saturday?
So
you
on
only
Saturday,
worked-
I do work 9 to 1, so she was in that time frame. If that helps you.
Right, and when you say till 1, do you take an appointment at 1 or is that when you leave?
I would take an appointment at 1.
So you don't know whether it was 9, 10, 11? et cetera.
No, I don't recollect.
Right, I have no further questions.
Briefly, if I can.
I'm
Hi,
sorry, what?
Hi, ma'am. How are you? I'm Michelle Manning. I
Hi.
represent the state. We've never met, right?
No.
Okay. Actually, just a couple questions. So that Saturday would have been about Saturday Memorial Day weekend would have been about 5/25, 2019. Does that date sound right?
Yes, that sounds right.
Okay. And you worked between like 9 and 1?
Yes.
Ish. Okay. And Michelle Troconis came in to get her hair cut. That was your testimony? Or hair colored?
Yes.
Okay. And she was happy?
Yes.
Nothing further. Thank you.
Nothing else.
You may step down.
Thank you.
Thank you.
Okay. You know it.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Jeffrey Law, Jeffrey Glaue.
And you may be seated.
Good afternoon, sir. Would you please indicate to the members of the jury where you are employed?
I am a Farmington police officer
How-
in the
how-
town of Farmington.
In where?
In the town of Farmington.
Could you tell the jury how long you've been an officer with Farmington?
I've been an officer in Farmington since 2012, or no, sorry, 2009. I left, I have to think this through, but technically just made 11 years.
During that time, and just indicate what positions have you held with the Farmington Police Department?
I started out as a regular police officer. I was assigned to the mall for a period of time, and the last 4 years I've been assigned as the evidence officer.
So
Court liaison.
we're down here in Fairfield County. When you say the mall, would you just indicate to the jury
Yeah.
about the West?
So
Farm?
Farmington has a substantial mall called the West Farms Mall. Part of it's in West Hartford, but most of it's actually in the town of Farmington. It's tends to be our busiest area in the town.
After you were assigned there, what else, what other positions did you hold?
Nothing substantial there. I mean, in Farmington, just for the time that I've been there, it was the officer, West Farms Mall, and now the court liaison officer.
And as the court liaison officer, are you also the individual who acts as the evidence officer for the town of Farmington?
Yes.
Could you just indicate to the jury, what does the evidence officer, let me rephrase the question. What is the evidence officer's responsibilities in the town of Farmington?
I'm responsible for logging in and logging out all evidence-bound property and tracking that, making sure court forms are filled out, moving those forms and evidence back and forth between court and various locations and keeping track of that.
Are you also responsible for receiving evidence from other law enforcement agencies?
Yes. So receiving evidence is in totality for wherever it's being generated. If it's being deposited with the police department, I'm responsible for it.
Were you subpoenaed to come here today?
Yes, I was.
Were you asked to bring something in particular?
Yes, I was.
Would you please indicate to the jury what it is that you were asked to bring?
Your Honor, this is a
Well-
point that state's objecting.
The issue of what you were asked to bring is not probative. So the court's going to sustain that objection.
Did you bring a document with you today, an envelope?
Yes, I did.
Is it sealed?
Yes, it is.
Could you just tell us where you received this from?
From the Connecticut State Police.
And is there a document that indicates that you received it from the state police that acknowledges your receipt of this document?
Your Honor, I'm objecting if I can at
Well-
this time.
Well, the issue is whether these questions are probative. Did you receive a document from the state police indicating that they sent you a document? The court does not see the probative value of this series of questions. So sustain.
May I see the document that you brought with us with you today?
And this is the envelope that the document's inside.
All right, I'm going to ask that this be marked for identification.
Well, any document can be marked for identification.
Could you just tell the jury, when did you receive this envelope?
Well, by my time period, so my property evidence label on it is listing that on May 13th, 2020 is when I logged it in as evidence.
Who did you receive it from?
I don't remember exactly the person, but it was a Connecticut State Police crimes detective.
Without actually stating the name right now, is the name of the individual indicated on the outside of that envelope?
Yes,
Did that envelope come from the Western District Major Crime Squad?
I believe it did.
Was it in connection with the case of the disappearance of Jennifer Dulos?
It was in connection with Mr. Dulos's suicide.
And showing you what has been marked as Exhibit PP for identification. You just tell the jury what that document is.
This is a receipt that I signed by the state police for the various items that they turned over to me as part of their processing the scene for the suicide or death of the deceased.
Does that receipt include the, whatever is that envelope that you're also holding, which is double Q?
Yes, exhibit 0390 is listed on this, and it's what their case number or tracking number for evidence listed.
You said 0390, what number?
So it's listed as exhibit 0390 handwritten note. And that's what their exhibit number also relates to the tag that's on the envelope.
Your Honor, I'm going to ask the witness to open, I'm not going to offer it through this witness. There has to be additional foundation laid, but I'm going to ask that the witness open the envelope so that the chain of custody remains in place. May I do that?
Well, is there going to be a challenge to the chain of custody?
There's not to the chain of custody at all, Your Honor, to the relevance and hearsay nature of this, but not to the chain of custody.
This witness is not going to testify concerning content. So if there's no objection to chain of custody, the envelope need not be open. There's not going to be a challenge to the chain of custody.
Okay. In any event, then I'm going to ask that the envelope remain as an exhibit for identification through this witness. And I do offer exhibit QQ. Let me just make sure I'm talking about the right one. I'm sorry, I'm offering exhibit PP, which is the receipt showing this witness's signature and receipt of that document.
Well, there's more on that document than just information concerning the receipt. So the document should be shown to the state.
I gave a copy.
You did, Your Honor, and I'm objecting to this coming in as an exhibit. It's, as Your Honor has indicated, there's more than what is in counsel is offering. I also don't see the relevance of it. It's also a hearsay police report statement. The witness has already testified as to its nature. I would object to it coming in.
Well, it's a receipt indicating that this witness received the document from the state police. But it's more than just a receipt. It just says more than state police sent this document on this date and it was received by the Farmington police. It says more than that. So the court is going to sustain the objection.
Well, it does indicate what is in the contents of that exhibit.
Well, that's the concern, counsel. Sustained.
Thank you. I have no further questions of this witness.
Nothing further.
Officer, you may step down.
Thank you.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
It's Sergeant Sean, S-E-A-N, Bailey, B-A-I-L-E-Y.
Sergeant, you may be seated.
Good afternoon, sir.
Okay.
Would you please tell the ladies and gentlemen of the jury where you're currently employed?
The Farmington Police Department,
How long have you been employed there?
19 years.
What is your current position at the department? What are you responsible for?
I'm a patrol supervisor on the day shift.
Over the course of your career, were you a police officer anywhere before you were a police officer in Farmington?
Yes, I was a police officer in Manchester, Connecticut.
As a police officer in Farmington, could you just tell us generally what was your assignment in January of 2020?
In January of 2020, I was
Your Honor, I'm going to object. Relevance.
Well, this was a matter that was preliminarily discussed outside of the presence of the jury. So what the court is going to do at this point, ladies and gentlemen, the court is going to take up legal arguments on a matter. And we'd ask you to just retire to the deliberation room while the court does that. So essentially, court understands this testimony to concern a document allegedly authored by Fotis Dulos, commonly referred to as a suicide note. Is that what this testimony is?
No, Your Honor, this witness is the one who was called to the house because Mr. Dulos was apparently missing from where he was supposed to be. He observed somebody in a vehicle. He observed Mr. Dulos in the vehicle with committing suicide with the hose, vacuum hose attached to the car. He pulled him out with another officer. He called the emergency rescue crew. He was present when at that time, I'll just note that that's when the note was seized. It then went to the state police. It was Detective Kimball who called this witness to go to the house. And in fact, and they found Mr. Dulos there. So the main import of this, even if the court does not end up allowing in the suicide note, which I'll note is marked as 0390 on that receipt, that the circumstances surrounding it, surrounding the fact that Mr. Dulos is unavailable is the thrust of this testimony. I would not be asking this witness. I do have one more who actually is the state police individual who actually seized the note and put it in that envelope. He's here as well as the name of the officers on the envelope. Maybe we don't need him. He's the state police detective from the major Western District Major Crime Squad. But if there's no objection as to chain of custody, it may not be necessary. I'll just note he's here. That's Detective Barbero. So this is to get to the background about why Mr. Dulos is unavailable. And I'm going to at least try to make the argument that the court then should allow in the suicide note as under the residual hearsay exception. But we would have to get into the background, which I believe separately is admissible before that note would come in. In other words, I wasn't going to offer it through this witness if there was going to remain an objection.
But death certificate is self-authenticating. That's grounds for anyone to conclude that the witness or Fotis Dulos is unavailable. So the court sees no reason for this.
The witness will also testify that Anna Curry was present at the time. He spoke with her, the other occupant of the house at the time. I would not even get into what she told him, but it would be to indicate who that individual was. There was testimony from Detective Kimball yesterday about that, and it was in the video. So.
The date and manner of Fotis Dulos' death is not relevant. The court, if there was evidence of a death certificate for counsel's purposes to show that Fotis Dulos is unavailable, the court may consider admission of a death certificate. But date and manner and who was present is not relevant. He's unavailable based on the death certificate. Does the state wish to be heard?
Yes, Your Honor. As I have indicated, the state feels as Your Honor said, anything that has to do with the actual manner and cause of circumstances surrounding the suicide is not relevant. The state's concerned with respect to the suicide note, Your Honor, and the use of the note as under the residual exception to the hearsay requirement. If I may be heard on that.
Well, that hasn't been offered yet.
That hasn't been offered. So that's really the crux of the matter, Your Honor.
So the court sees no reason for testimony if the state is willing to accept that there's a death certificate. On the death certificate is the date of death. It's self-authenticated.
Yes.
Well, the second argument I would be making is, although I can see that the Connecticut rule of evidence limits dying declarations in a prosecution side to dying declarations concerning the victims of a crime, I would make the argument under Chambers versus Mississippi that it's unduly restrictive when the defense wishes to offer a dying declaration, which otherwise would be considered have evidence of reliability because it not only was written and found with Mr. Dulos, but refers specifically to the fact that because of the charges he is going to, he's taking this action. So the timing is relevant to that argument, as well as the question of whether or not it needs to come in under the residual hearsay exception. The jury at least needs to know that it was that the death was under the circumstances time-wise, that it would be material and relevant for the defense. That's my point.
Well, again, the state, as the court understands it, would not object to the admission of a death certificate. Now, the residual exception to the hearsay rule, first, counsel, the court believes is correct in that the dying declaration exception refers to the dying declaration of the victim. So, in actuality, unavailability would not even apply in this case. However, the court sees the progression of counsel's argument. Secondly, even if the court were to consider the residual exception, the court would use as guidance the dying declaration exception. But the dying declaration exception requires, there has to be indicia of reliability. And so the dying declaration exception requires that the statement had to be so far against penal interest. Let's just use that example. If this were not the defendant in the case, that a person in the declarant's position would not have said it unless he or she believed it to be true. Well, first, if the court is to use that as guidance, the court cannot see, based on the facts of this case, that there's a statement against penal interest, because there's no
I
indication.
can't make that argument. I'll be quite frank, Your Honor. It was not against Mr. Dulos' penal interests.
Not against his penal interest.
No, but there were other indicia of reliability, and I would have elicited that. I'll just state for the record, so that we're here. This witness, the department received a call. I believe he received a call from Detective Kimball saying that Mr. Fotis was supposed to be in court at that time, and it was shown that he had not left his home. He was sent there for those purposes, only to discover that he was in a running vehicle with the garage door closed. The lights were on. He broke the window together with another officer. They pulled him out. And so the indicia of reliability and the fact that the note was taken on that date goes more to the fact that it was related to the fact that he believed he was going to jail. So in a way, it's literally against his penal interests, although the statement itself exonerates my client. So that's why I'm arguing it as not as a dying declaration, but instead as a residual hearsay, or under a Sixth Amendment right to present a defense exception, which Connecticut has not yet acknowledged.
Well, again, the court understands, believes counsel's argument. The fact that the statement does not include an admission militates against a finding of trustworthiness. Even if it included an admission, there's no using the guidance of the code concerning statements against penal interest. There's no indication that Fotis Dulos intended to be alive for prosecution. So it could not have been a statement against penal interest, because the code contemplates the declarant being alive to face prosecution. He did not intend to face prosecution. So it would not even be a statement against penal interest. It's essentially an effort that counsel may argue is memorialized and trustworthy, but the court sees that it doesn't meet the measure of trustworthiness. There's no admission, and he didn't intend to go to prison. The court wouldn't allow a statement.
All right. In any event, is the court also precluding from the defense putting on the circumstances surrounding the death?
Yes, that's precluded.
Well, then I don't have any other questions of this witness.
The jury can come back out.
And then I'm also going to release the Detective Barbero, since there would be no need for him to testify about taking the exhibit and delivering it to the Farmington Police Department.
Thank you.
And then I will offer the death certificate as exhibits.
Will the counsel stipulate, please?
Yes, Your Honor.
Yes. I just have one question. Did you become aware at some point that Mr. Dulos had died? Yes. Your Honor, I'm going to mark this.
I have no objection.
And what's the
RR.
RR admitted as full?
It was on now. Oh, it's not my phone. Oh, okay. Thank you. Got it. Thank you. And you knew that Mr. Dulos actually died in New York, not in Connecticut. Yes. Right, and this is Exhibit RR. It's a copy of the death certificate showing that that Mr. Dulos died on the 30th of January of 2020 in Bronx, New York. Signed by the medical examiner of the city of New York. I have no further questions. Thank you.
I have nothing, Your Honor.
Sergeant, you may step down.
Your Honor, I don't have any other witnesses ready for today.
Thank you. Will a witness be ready tomorrow at 10 o'clock?
Yes.
So, ladies and gentlemen, that concludes today's session. Please do not discuss the case. Please regard no media reports about the case, and we plan to see you tomorrow morning at 10 o'clock.
Yes, this judge is very good for explaining what the offering is and what the reason for his ruling. So I really enjoy his the job that he does, because it really helps to make things clear to everyone. So we'll do this again tomorrow. The defense may possibly rest Friday or Monday. They're figuring Monday, but possibly sooner. So I'm guessing that the fact that they can't get this evidence regarding Fotis cause of death and the him saying, I can't live another day as an innocent man being accused and so forth. That's not a dying declaration. That's a self-serving statement. He wants to get out of being prosecuted. And, if he was in the hospital after trying to gas himself and he said something at that point, it would have more weight because death is more immediate at that point. It seems like he may well have taught law, because he's very good. Yeah, I'd love to see some more cases tried by this judge. So if there's another Connecticut case, we'll have to keep an eye open for him. So the jury was sent home already for Adam Montgomery. They finished deliberating at 4 p.m. on the East Coast, and they didn't, anybody else would have had the jury stay late a few hours or something, but, they sent him home early, so go figure. So we'll keep an eye on the verdict watch tomorrow for Adam Montgomery. The Law and Crime poll was running at 97% guilty. I don't think there's any doubt what the verdict is going to be. Tomorrow we'll do this again, and we'll continue to watch the closing arguments for Adam Montgomery during any breaks. And so we'll see you all tomorrow, and have a great afternoon and evening. We'll see you. Bye-bye.